New Haven, can you turn the camera on, please?
Officer Meisinger, I can see him. Can you not see New Haven?
I cannot see anything at New Haven.
Okay.
Is there a way they can fix that?
Yeah, officer, I can see that your camera's on, but one of our rooms here isn't picking up the video. So on the tablet, do you see the little arrow next to the video icon?
Yes.
So if you push the arrow, I believe there should be a slider button for integrated camera.
It's on.
If you turn it off.
Okay. It's off.
Officer Meisinger, do you see anything now?
No, there's no change. Should I dial them back?
Yeah, so if we leave that off, we can hang up and try to redial them.
Okay, so maybe I'm gonna call you back.
Okay. All right.
Yo, Sheehan, can you sign back on at 10:30, please? Just because I have a lot of people participating in this hearing currently. Just so I need the screen. You're on at 10:30.
Okay. New Haven, I apologize. When you press the arrow button and that that options window pops up. So there's a not integrated camera, there's an enhanced framing button.
Right.
And you can turn that off.
Okay. It was off, but I think soon as if it resets, then it automatically comes on.
It does, yeah.
Yeah, okay. Good now?
We still don't see you.
Just to let you know, on our side, I can see him.
And I can also see him in my video room, separate from Officer Meisinger.
Okay.
Up a little bit.
But Officer Meisinger currently can't. All right, if everyone can, New Haven, if you can just stay connected as is for a moment, I'm going to try one thing on our end.
Okay.
You didn't.
She didn't. All right, New Haven, we do see you now. Thank you.
Okay, no problem.
So I believe we're waiting on P.O. Richardson. Or is she not participating?
No, she is not going to testify today. It's just me.
Right. All right, thank you. So we are waiting on, I believe, Attorney Creizman.
Correct.
Are they participating still today?
Yes, he's just experiencing a little trouble logging in. So he says that he's able to view the event but not join as a participant. If anybody has any troubleshooting ideas.
Sure, I'll let our IT know as well. Attorney Najee, you are muted on your side currently. I'll see if that's our issue or.
Perfect. No, I was able to unmute. Yes, he has been trying to log in for the last 20 minutes. And for whatever reason, he can watch the proceedings, but can't speak or participate just like we can. And
Has he joined from the web browser? Because this will not work in a web browser. And it will not allow you to unmute.
I see. I think he has tried on the Teams app as well, but let me. I also cannot see the New Haven part as well. I don't know if that's an issue.
It's not an issue for us. I mean, if it's all right with you. I mean, because we have too many, there's a lot of people participating, so the screens may not all fit.
Oh, okay, I see. I can't see Charles.
Do you see a box that says NH or NV as if it were a placeholder for New Haven?
I do see that, and I see that it's live, but I don't see any images on it.
That was the issue that we were having that resolved when Officer Meisinger's room quit and rejoined the hearing.
So should I do that?
If you would like to try and resolve that issue for your computer, I would suggest you just leave the meeting and rejoin. And a phone has connected. I believe this is going to be Attorney Creizman.
Eric, is that you? Eric, unmute yourself. Yes.
I can hear you.
I did.
Yes.
Okay, good. Great. Thanks.
You just might have to speak up a little bit because you do sound, or raise your volume if possible.
Oh, sure. Let me see what I can do here. Let me see if I can fix that.
Christina, can you see Charles?
I can, yes.
Okay. Let me see. I don't want to delay it. Okay.
And we have CO Donovan. Can you hear us?
Yes, I can hear you guys.
Great, perfect. All right, so everybody is here then, and I can hear everybody. So are you okay to proceed then, even though you can't see the box?
As long as one member of our team can see Charles, I don't want to exit out and then not be able to rejoin.
Yes.
Okay, so we will get started now then. Mr. Cornelius, you can hear us, correct?
Yes.
Okay, perfect. Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is revocation hearing concerning Cornelius Charles, number 296776. Today is March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in New Haven Correctional Center. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Charles Cornelius, 296776.
And we have a parole supervisor present. Please identify yourself for the record.
Absolutely. My name is Micah Mann. I am a parole supervisor with Parole and Community Services of the Department of Corrections.
And we have counsel here today. Can you please all identify yourselves for the record?
Yes, this is Genny, Eric Creizman, and Christina Gotsis from Morrison Cohen on behalf of Charles Cornelius.
Thank you. And just to note, we also have a witness who is present today. Can you please identify yourself for the record, sir?
Yes, my name is Panasan Tongmei-Vong. I'm correction officer with Connecticut Department of Correction.
Thank you. So this is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weeder evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is Elysium, place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to an appropriate sanction My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony in any relevant documents. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure before we begin, sir?
No.
Okay, you have important rights today, the right to have an attorney present, and you have counsel here today. You have right to receive the written notice of charges of violation. Did you receive the written notice?
I don't know.
Counsel, did you review the violation with Mr.
Yes, we
Cornelius?
have.
Okay.
Yes, we have.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
Okay, so we will now review the charge the state your parole officer is bringing against you and the information underlying each charge. So PS Mann, please read the charge. Oh, you are muted.
Thank you very much. Yes, so charge number 1 under weapons. On December 26, 2024, New Haven Police Department executed a search warrant of a storage unit at self-storage of Stratford that was in your name and that you had control over. Found during this search were several knives that are over 4 inches in blade length, consisting of a switchblade and or a metal knuckle. Your GPS placed you at this location as recently as 12/22/24. On 12/26/24, a search of your residence was conducted by Parole and New Haven Police Department. During this search, 6 knives, which are either over 4 inches in blade length, consisting of a switchblade and or metal knuckles, were found at your parole-approved residence in areas that you were able to access. All but one of these weapons were located on a kitchen countertop in plain sight next to your identifying information. This is a violation of your parole conditions. Specifically, I will not use or have in my possession or control any firearms, ammunition, or any other weapons.
Thank you. And the state
You're
has
welcome.
filed the following exhibits that are pre-marked for identification purposes as the evidence was put in the record at the time of the preliminary hearing. That evidence remains. There is additional evidence that was submitted by the state, which is Exhibit H, which contains additional photographs. Exhibit K is an incident report supplemental. Exhibit L, supplemental updated. And Exhibit M, which is the at-night GPS map. Did you receive notice of parole violation report, and the other documents I marked for identification? And did you review that information, sir?
Yes.
Okay, and defense counsel has filed the following exhibits pre-marked for identification purposes as Defense Exhibit 1, risk protection warrant. Exhibit 2, defense exhibit, first request potential defense exhibits. Exhibit 3 from defense, second request witness. Exhibit 4 is alleged latex gloves. Exhibit 5, alleged camo can. Exhibit 6 is side of alleged camo can. Exhibit 7 was 8/28/24 Cornelius letter. Exhibit 8/9 are storage locker photos, storage bin photos. Exhibit 10. Exhibit 11 is picture of organized storage box. Exhibit 12 through 17 is organized collectibles and envelopes. Exhibit 18, 19, 20. Pictures, Jan Hafnick with aged, his picture of knife. Exhibit 21 through 23, defense exhibit, protect mammoth pictures as well. Exhibit 26 through 27 are pictures of Walton mammoth. Exhibit 30 to 32, Walton mother of pearl photos. Exhibit 33 to 35, Walton Timicus photos. Exhibit 36 was the American Edge invoice, exhibit for Defense 37, 2024 early termination package, letters and article, and exhibit 38 is the Charles Cornelius motion. So all these were reviewed as well prior to this hearing. To defense, do you need to continue the hearing to obtain any additional evidence?
This time, Your Honor. I mean, not at this time.
Oh, what was that? No, okay. Sorry, you cut out. So at this time, the witness has been called by defense to be here today, which is CEO Fansong.
I don't know when you would like me to do this, but the state does have some objections to allowing this witness to testify.
All right, so first of all, there's no other witnesses that are being called today other than the CO that we have present today? Is that,
For the defense.
what was that? Sorry, you cut out.
I said not for the defense, and I'll put it on the record that we may not ultimately ask the correction officer any questions at this proceeding, but we wanted to make this individual available should the need arise during the hearing.
Okay, so PS Mann, what is the opposition to him being here?
The state strongly believes that CO Tong Many Vong's testimony is immaterial and really repetitious of any testimony that I am going to present.
Okay, so at this time, there's no problem with, I find no problem with him being here present, so we'll move forward with the hearing. So at this time, the state is going to have an opportunity to call witnesses, present evidence, and speak to any of the evidence submitted at this time. So PS Mann, I'm going to swear you in, as well as Mr. Cornelius, in the event he would like to speak today. Can you both please raise your right hand, as well as CO Thomavong, just in case you do speak today, please raise your right hand. You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give, so in this case, should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
I do.
I do.
All right, so at this time is the state's opportunity to speak, if you'd like to at this time.
Absolutely. So at the preliminary hearing, Parole and Community Services presented the evidence that we had regarding Mr. Cornelius violating his parole conditions regarding possessing weapons. At that time, defense counsel did not really object that this violation occurred. I don't think it's nobody has stated that Mr. Cornelius did not have said weapons. The state further proved at the preliminary hearing under state statute 53-206, many of those weapons are considered dangerous weapons under Connecticut general statutes. Therefore, I don't think any of that was really contested. Defense presented a case that really hinged upon that these were weapons that Mr. Cornelius had no intention to use, and the seriousness of the nature regarding the weapons. Subsequent to the preliminary hearing, we also have submitted evidence, and I just want to also point out, I should have said this at the beginning, that due to the sensitive nature of these additional addendums that we have submitted into evidence, the state is requesting that, at least for this public hearing, that any names that were included in that evidence and specifically addresses, private addresses that were included in that evidence, that we don't verbalize those names during this hearing. That evidence was extremely private in nature. It contained employees at both the Board of Pardons and Paroles. It included parolees here at Parole and Community Services, and it included the children of employees at Parole and Community Services. So we would kindly request that names and addresses specific to that evidence is not shared during this public hearing. Having said that, in regards to the serious nature of the weapons that we found.
That'll be for the second part of the hearing regarding seriousness. If you have anything else just regarding the charge.
I will bring it up then. Go ahead.
So it is now defense's opportunity. If you'd like to call witnesses, present evidence, or speak to any of the evidence submitted at time regarding the charge.
Officer Meister, we do, and I think we're going to do this in two parts. I think my colleague Eric Creizman is going to go first, and then I will also make some arguments later on. But Eric, take it away.
Good morning, and I'm sorry that I can't actually see what's going on, or you can't see me either. Maybe that's a positive for everybody, but let me just begin. Okay, I've represented Charles Cornelius for 14 years, and I've gotten to know him very well. I've got to know the opportunity to know his family. I knew his father for several years. I knew his, know his mother for all this time. And this is an emotional case for me because I know Charles so well, and I know his mother so well, and it bothers me that I think that he has been profiled and mischaracterized as a dangerous person for so many years. And the fact of the matter is that this assessment is really based on no evidence, and I want to go into that a bit. But let's start with, let me tell you who Charles Cornelius is, because since he's been out,
well,
would
this go with the second part of the hearing when we have regarding seriousness? Right now we are focused on the violation.
I think it would go with, yes, I think this would go along with the second part of the hearing better, actually.
Okay.
That's my,
Okay.
So right now we're looking at the one charge that we have. Is there anything you guys want to say just regards to that one charge?
Yes. I'll interject at this point. So I think the question is whether or not Charles violated this term of parole, right? Whether he possessed firearms, ammunition, or any other weapons. And frankly, I think the answer is no, he did not violate. He didn't have any guns. There's been no evidence of that. There's no evidence of ammo, and he didn't have any weapons. And now I know that, Supervisor Mann has said that we concede at this point. I disagree. And I want to be clear and distinguish between the two issues here. Are these knives? Yes, but that by itself does not make it a weapon, right? Having a knife is not enough to violate his term of special parole. I mean, he's allowed to use steak knives to eat. He's allowed to use knives to cook with. He hasn't been violated for that. And so I would urge you to consider, what makes it a weapon, right? And this goes to the point that I raised earlier in the preliminary hearing. Where is the intent to harm? A weapon by its plain definition, is an item that's used to cause injury, that's used to inflict harm on other people. And we don't have that intent here, right? All the evidence that we have submitted on behalf of Charles shows that he had no intent to use any of these knives to harm anyone. He's a collector. And Eric is going, my colleague Eric is going to speak more about, Charles and who he is and what his family situation is like. But he is an artistic individual who collects these valuable items for collectible purposes. We've submitted a lot of images to you to consider, and these are images that I don't think you saw the first time around or in the state's evidence, but they are images of objectively beautiful knives. They are expensive. They were in his storage unit. So, for example, we can take a look at the Defense Exhibit 30 and 31. I mean, this is the mother of pearl angel wing knife. It's purple. It has mother of pearls on it. It's worth $2,300. All right. We have Defense Exhibit 23 to 24. That's a mammoth Gotsis engraved knife. It's made out of mammoth ivory. That alone is worth $1,200. DX18, which is the Jan Hafenik knife. It's shaped like an artifact. It has curved edges. This is not an item that you would use to commit harm. Same thing for DX35. It has a purple colored handle. It's objectively beautiful. And we have that, a note from a seller, DX Defense Exhibit 36. The seller agrees that this is a stunning object. And we put in all of this information and we put in photos of how these knives were cataloged and stored. I mean, first of all, these knives are carefully wrapped. They're wrapped in towel and sheets. They're then packaged in envelopes. They're marked. They're cataloged with the name, the price. They have photos of what, of their value, and they're cataloged in a storage container that's then away in a storage container and locker. I mean, this is how you would package and store expensive items that you cherish. It's not something that you would use to cause harm or mass destruction. And I think that's an unfair characterization of what's going on here. And I would say another point about why, there's no evidence that Charles intends to harm anyone is just look at his history, right? Yes. Did he serve time for a felony conviction? Yes, but he served over 10 years on that, all right? And he was sentenced to maximum or medium security prisons, and there's not been a single allegation of any violence, any harm caused to others, and he's in jail. And this is for over 10 years. Then he's out on special parole, which we all know contains very stringent conditions. He's heavily monitored by the state, and he's heavily monitored by Hopkins. He is on constant surveillance 24/7. They follow him to doctor's appointment. He takes care of his mother. They follow her. I mean, it's nonstop. And this is the first time we're appearing here before you on a parole violation. And I think we can all understand the significance of that. For someone to be on such close supervision for so long, it's rare to have that compliance. So again, I think this is important because, if the narrative is that he is so dangerous, that he's such a danger to society, that he's using these items as weapons to cause harm, the facts do not support that narrative. And I think it's important to also recognize that his prior parole officer, Erica Richardson, actually recommended that his term of special parole be terminated early. And but for Hopkins, he probably would have gotten that. And I want to also just quickly touch on, the exhibits and supplemental exhibits that the state has submitted. And I want to focus on their Exhibit E, which is the law enforcement report that actually prompted the search of the storage unit. All right. If you read through that report, there are inaccuracies in there and misrepresentations that, again, go towards framing Charles as this unstable individual that, again, is not supported by the facts. Hopkins apparently told law enforcement that they saw Charles going into a storage locker with latex gloves and an ammo can. To date, there has been no evidence of that. None. There's no latex gloves. There's no ammo can. And in that report, it says Hopkins saw him come out of that storage unit without an ammo can. There's been nothing. There's been no physical evidence of that sort. And in fact, we've submitted the opposite. We've submitted DX 4 and 5 that shows that these latex gloves are blue mittens and that any ammo can is a Home Depot, is a type that you could buy at a Home Depot. It's a field box that can contain anything. And I would also object to a reference in there that I think calls Charles unstable based on prior, psychological exams or evaluations. There's been no record of that. None. Because he has not submitted to any mental health exam by the state. All right. So like that, again, I think is an incorrect and inaccurate misrepresentation of who he is, which has brought us here today. I also, and also, on that point, Charles isn't someone who is not monitored. If there's been any allegation that he has exhibited unstable behavior at any point in his parole, we would have heard about it and you would have heard about it, but we haven't. And none of the evidence that, the state has submitted undermines the fact that he is not intending to harm anyone. First of all, searching for information online is not a crime. All right, he's entitled to know who's involved in his case, who has provided adverse information. It's just not a crime. There's been no threats, there's been no confrontation and no acts of violence that anyone can point to. And the same thing goes for the electronic monitoring. I understand the state's inference here. I understand what they are trying to argue, that he is somewhere that he should not be. But for every negative inference, there's a perfectly innocent explanation. You cannot tell me that that GPS exhibit has any explanation. It's all speculation. He could be driving, he could be walking, he could be there to get a sandwich at a sandwich shop. There's a park there, there's a cemetery there. We have no idea. And I think it is unfair for the state to suggest that he is there for a negative purpose when there has been nothing on the record explaining why he was there, what he was doing, because you know what? No one ever asked him. And I think so, those are my main points against the actual evidence on the parole, on the alleged parole violation. Frankly, I don't think there is a violation. These are not weapons. There is no intent to harm. And I'll defer to my colleague to talk more about the history of the case, because I think that's really important. This is not a standard, revocation proceeding involving someone, who has no history or has a standard history here. This is there's a complex background. Charles has been subjected to custody and also to a supervision that I don't think anyone has seen in the state of Connecticut, much less the US. Like, I've never seen a situation where he is monitored by parole on stringent conditions and then followed by private security over the course of 10 years.
I would definitively like to respond.
All right, counsel, are you done with this portion at this time?
Eric, do you have anything to add?
No.
All right, so I'm gonna turn it over to the state then if you'd like to reply.
Absolutely. So let's start with the first point, which was I appreciate counsel's subjective opinion that these knives are not dangerous, and that is great. They might be very valuable and beautiful subjectively, but I would like to deal in facts. And the facts are that objectively, the state statute 53-206, and I just want to read a part of that, because there's a part of that statute which clearly defines, enumerates what is considered a dangerous weapon. These weapons are a slingshot, an air rifle, a BB gun, blackjack, sandbag, metal or brass knuckles, dirk knife, switchblade, or other knives having an automatic spring release device by a blade that is released from the handle, having a blade of over 1.5 inches in length, a stiletto, other knife with an edge portion of the blade over 4 inches in length. So the objective fact is that Mr. Cornelius and the defense has basically made our point for us that he bought these knives. They are considered dangerous weapons under Connecticut statute. Therefore, his violation of I will not use or have in my possession or control any firearms, ammunition, or any other weapons, there is no question that that is a clear violation of that. So I understand the subjective opinion that these are beautiful pieces of art, but the fact is that they are under Connecticut's state statutes. They are also considered weapons. I would also like to get into the last point that council made regarding, and I was going to get into this a little bit later, but regarding the evidence that we have submitted that shows that not only did, and listen, defense is right. It is not illegal to take screenshots of personal information that is publicly available online. And that is what we found in Mr. Cornelius's phone. However, it should be noted that those personal information was related to people who Mr. Cornelius appears to feel have somehow harmed him or have been involved in his case. That goes directly to his underlying charges, of which he is serving a long incarceration and special parole period. I think that needs to really be, if you want to talk about the totality of the case, let's talk about that the exact same behaviors, just about, in which he received a extremely lengthy sentence is also being played out right here in real time. So on his phone, what did we find? What we found are screenshots of personal and private information that of home addresses of Board of Pardons and Paroles employees, Parole and Community Service employees, and this is what is perhaps the most disturbing to us. He also had screenshots of a previous parole officer's daughter's address. And I'm going to also put this on the record as well. This is very, very important. Not only were there screenshots of the actual address, there were screenshots of a Google Street View of that daughter's workplace. That is extremely disturbing to the state. Now, again, these are just screenshots, and you might say to yourself, well, he's just taking screenshots. Then, on 3 occasions, I will give you the dates right now. On February 8, 2024 at 2:27, on March 20th, 2024 at 1:25 p.m., and on May 23rd, 2024 at 1:28 p.m., Mr. Cornelius went to one of those addresses of a Board of Pardons and Parole employee that he had screenshotted. Council has noted that, well, there's a park around there, that he could be doing anything. And if you would like, I can share my screen and we can look at the actual map of where this address is. This is a deep in a residential neighborhood. Not only that, but this is a one-way street on a cul-de-sac. And on that cul-de-sac is only 5 or 6 residences. One of those residences happened to be the address of that Board of Pardons and Parole employee. I will contest that there is absolutely no reason why an individual would happen to be at that exact address. This is not a address that is on a main thoroughfare. You have to go way out of your way to get to this address. It's down a one-way street on a cul-de-sac. He was there on 3 different occasions. So again, let's look at this, and I think the other attorney is going to talk about, you know, the totality of this case and how Mr. Cornelius has, you know, been a victim in all of this. The totality of the case is that Mr. Cornelius has a long history of becoming fixated on individuals who he believes have done him wrong in some way. We have now provided evidence to the Board of Pardons and Parole that shows that perhaps those behaviors are continuing. And that is why it would be an egregious mistake to allow Mr. Cornelius to an early release from this revocation before his end of sentence.
All right, so counsel, you can either respond now, or we can also, we're going to get a chance to talk about the seriousness of this after the first part of the hearing.
I would just like my colleague Christina Gotsis to respond to, we'll respond to the other points as well, but to the issue of Connecticut General Statute 53206, I do believe that Supervisor Mann has overinflated the statute per its specific language, but I'll let Christina defend this point.
Hello, hearing examiner Meisinger. I just want to point out, as has been characteristic of the evidence and the testimony we feel has been introduced by the state against Mr. Cornelius, that there are important facts that are being left out and or mischaracterized. So Parole Supervisor Mann has referred to statute 53206 and has purported to read a definition to you of what is a dangerous weapon. I do want to read to you that the title of the statute is "The Carrying of Dangerous Weapons Prohibited," and the actual language says that any person who carries upon his or her person, and then it goes into this definition: BB gun, blackjack, metal or brass knuckles, as Officer Mann said. So I do want to say that the statute he's explicitly referring to and citing to as a parole violation and as Mr. Cornelius having in his possession or control is not actually applicable here, because this statute only prohibits the carrying of these dangerous weapons on the person.
I would like to respond to that.
Go ahead.
The fact that you cannot extrapolate what the state deems as a dangerous weapon because we did not happen to find that these weapons he was carrying, I think it's not reasonable to understand that the definition of what the state of Connecticut deems to be a dangerous weapon is somehow thrown out because he didn't meet the criteria of this one statute. I think that's unbelievably unreasonable. And the fact is that the state obviously has defined what they believe a dangerous weapon is, whether it was found on his person or not. We have provided evidence, and defense has admitted that he was in possession of this. So that is muddying the waters, if you will. The definition is the definition.
I don't need to extrapolate.
Well, Christina, I don't want to go into tit and tat because we're now arguing over the application of a legal statute, which Charles has not been accused of violating, nor do we believe he has violated. I think the point is that there was if I recall correctly, there was an indication that he did violate the statute, and he did not. He did not violate the statute because he did not have these items on him. And I think that goes back to the issue of, did he have intent to harm? No, He did not. These items were packed in a storage unit. And I do, look, if we want to get into a legal discussion as to what the statute defines as a deadly weapon, we're happy to submit briefing on this. But I don't think that's the point here.
Thank you. All right, so is there any other comments before I announce my findings with respect to the charge?
No.
Okay. All right, so I'll be right with you with my findings. So regarding that charge number 1, I do find you violated that condition, obey all laws, weapons. This is based on evidence as well as testimony provided in support of the charge, which we have exhibits A as well as E through I. They do meet the elements of violation for the Board of Partisan Parole regarding that charge. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So, yes, Mann, at this time, would you like to say anything regarding the second part of the hearing?
I think that I have covered a lot of it. Again, I will go back to counsel's defense that there is no evidence that Mr. Cornelius ever intended to use or that these knives. And the facts of the case are that we don't know that. It is highly suspicious that Mr. Cornelius went to the address of a Board of Pardons and Parole employee on 3 separate occasions, not once, not twice, but on 3 separate occasions. I have already spoken about how it is unreasonable to believe that this was just coincidence, that he happened to be in the area. This was not a town, anywhere near a town that he lived. And what the GPS actually shows is he specifically went down there, he went to this address, and then he went back to his hometown, to his home. He was not engaging in other activities. It is clear from the evidence that we have that he went to this address with a certain purpose. And again, I want to bring up the totality of this case, which this is ominous that this is based upon his original type of offense, which is extremely disturbing. I also want to, again, bring up the fact that not only did he have in his phone personal information about individuals who may or may not have testified against him, have written reports that he deems were against him, but the child of one of those members. That is, being a father myself, that is extremely disturbing. And so, again, it is on the record. It is no secret that Mr. Cornelius has his end of sentence very soon, relatively in May. The state would definitively ask for a complete revocation of the rest of Mr. Cornelius's parole, given all of those facts. And I reserve the right to comment after we hear from counsel.
All right, counsel, if you'd like to speak at this time.
Yes, thank you very much, and I appreciate it. Okay, so I'd like to talk a little bit about Charles Cornelius and talk about the good person that he is, and how he's really made enormous progress over the last 8.5 years since he's been out on special parole. Charles is the sole caretaker of his 83-year-old mother. He drives her wherever she needs to go. He takes her to medical appointments, grocery shopping. He helps out with the handy man work in the house. He basically does everything to make his mother's life easier. While he's been in prison, he calls his mother at least twice a day to just make sure that she's okay. And you know, as you may know, his father passed away while he was in prison, and that hurt him very, very much, that he couldn't spend his last days with his father. And so I just want to point that out, that he's got great love for his mother, and his mother misses him, and she's worried about him, and he's worried about her. Okay. Now, something else that might surprise you, but every Passover, Rosh Hashanah, Hanukkah, okay, who do I get a card from? Not every single time. Charles Cornelius. He's the only person that I can depend on who will send me a card for those holidays. We discuss books. We discuss philosophy. We discuss the justice system. Charles is a complicated individual, and the key here, and what I'm going to ask you to do, hearing officer, is to basically not choose revocation, but choose therapy and oversight to over this last month and a half to honor the parole's promise of rehabilitation, which is what parole is all about. It's not about punishment. Charles here may have slipped by ordering, by collecting these knives, but and he may have slipped in it. Well, let me go on. Let me actually talk about this, because the history of Charles in jail. Okay, he's been in some of Connecticut's high security prisons and medium security prisons. He spent 14.5 years in prison. He spent 14.5 years in prison. The first 10.5 years, the first 13.5 years, or 13 years were in Connecticut state prisons, and then he spent another 1.5 years in federal prison. Okay, he has one infraction, which was having a hot water heater in his cell. That was basic. That is it. There was never any violence, threats, no gangs, no proselytizing of hate speech or anything like that. That he's been portrayed as some sort of monster, some sort of future Adam Lanza. If we only, we basically, Hopkins takes credit for basically stopping something that they invented in their own, on their own. There's just no basis to think that Charles Cornelius is a dangerous person. Okay, and there was one psychiatric evaluation of Charles Cornelius, and that was provided at sentencing. And it was by Dr. Mark Mills, who evaluated him with the MMPI-2 and PAI tests. These are rigorous scientific tests, and concluded there was no evidence of violent tendencies and a low likelihood of future harm. And Judge Blue characterized Charles as someone who needed to be warehoused, who basically was going to blow up a building and so forth, because he branded him a racist and someone who was basically stockpiling weapons. At the end of the day, who proved to be right but Dr. Mills, the psychiatrist who examined Charles. The fact of the matter is that while on the 8.5 years while out on special parole, he's had a verbal warning. This is his first infraction on special parole. And the idea here is that we want him to transition to the community. We don't want to I think that he's been in jail already for almost 3 months. Isn't that enough? Why don't we use this month and a half to try to have Charles go to therapy? Okay, and the therapy that I'm going to recommend is that he at his own on his own expense hire a therapist who will see twice a week. Okay, and the Board of Paroles is entitled to find out one thing: is he a danger to himself or to others? And that's really the point here. That's what we really need to do. We should encourage Mr. Cornelius. We should encourage Mr. Cornelius to deal with certain things, deal with the stress, deal with his trauma in a way that is constructive. And I think that we can all agree with that, because look, the board of Paroles, we have documents that show that the Board of Paroles was actually said that we don't think Mr. Cornelius should be surveilled 24/7 by Markle Investigations, which was hired by Hopkins. We don't think he needs to be surveilled the entire time. And the Board of Paroles rightly allowed him to live with his mother against Hopkins' wishes. And I think that today the Board of Paroles should do the right thing and stand up and try to get Mr. Cornelius to ease his transition to the community. So let me go into the specific charges here. The knives. Let's talk about the knives. Okay, there was. I can see the concern that they're knives. But they aren't tools of harm. They're a passion. They were kept in their original packaging in a storage locker. This isn't a stock pile. This is an interest that he has, and it fits a man drawn to craftsmanship, not conflict. He's never wielded a weapon against anybody. And so going to the searches, the internet searches and the drives that showing him near the homes of people who are affiliated with the board, it's easy to misread, but this isn't menace here. It's a response to relentless pressure. Since starting parole, 8.5 special parole, at least outside of federal prison, 8.5 years ago, he noticed surveillance. There were cars trailing him, people walking behind him. I remember getting a call from Mr. Cornelius telling me, Eric, there's people following me. I know that there's people trailing me. And I thought that Charles was simply paranoid. And I said, you that can't be true. But in fact, the first parole officer that he had actually assured him, no, that you know who that is? That's the FBI that's watching you, and agree to a psychiatric evaluation or they'll arrest you. Okay, that was a lie, and it was a lie that special parole officer knew was a lie. It was a tactic to force an unnecessary evaluation. The reality was that it was private investigators hired by Hopkins to shadow him day and night. And the parole board met with the Hopkins officials who labeled Charles a danger to the community and their school. And you guys advised them that round-the-clock surveillance wasn't needed and it might set him off. It did. I mean, he felt the eyes, the weight of this surveillance, and it rattled him. And when he challenged this surveillance, not by violence, when he challenged it in court, The response was, look, the law permits you to be surveilled so long as they're not looking into private spaces, right? And so long as it's in the public gaze. So Charles has been followed around, in addition to his GPS, he's been followed around by Hopkins for many years at this point. And why? The question is why? Why is he a threat to Hopkins? Why does Hopkins write to the parole board in August of 2024 and say that they're a victim of Mr. Cornelius's offense? They're not a victim. They're not a victim. There is no victim of Mr. Cornelius's offense. He collected a number of weapons, illegal weapons, and therefore he served time. He was convicted of a crime. Should he have served this much time? No. He's been deprived of 24 years of his life, 14 and a half years in prison, and then 8.5 years on special parole under strict supervision. And we can see that he's made progress over time. And I'm sure, as the Board of Paroles is well aware, people sometimes slip up during these kinds of periods. And what was going on here? What was going on here is hypervigilance, which is psychology. It's a psychological concept. It's 24 years of scrutiny, like here, would make you hyper aware, scanning for the next move against you. You know, he's looked up board members. He clearly didn't confront anybody. He didn't threaten anybody, right? No one was threatened. No one was confronted. This is what we're talking about. He's trying to understand the case. He's surviving. He's trying to respond to a system that's hounded him for many, many years. He's a man pushed to his limits. So what's the right path, right? Revocation now, after 3 months locked up since Christmas. It ignores his records for Hopkins' panic. He's not a shooter, okay? And Dr. Mills' 2004 evaluation has proven true across 24 years. Judge Blue's fears have never materialized, okay? There's no intent here to harm anybody. There's no intent here to threaten anybody. And the revocation of his parole would tear apart for another month and a half his mother's sole lifeline, and her well-being and stability depends on Charles being around the house. Why don't we have him go into therapy and address these issues so that he can better deal with these triggers, okay? The fact of the matter is that every single time that Charles has been, he can't be examined. Every time he's reached out for help, every time he's wanted help, he's been concerned, and rightly so, that the psychiatrists from the state are simply are basically out to portray him as a active shooter and to lie to him, to get him to talk to them. There was David Rentler, who visited Mr. Cornelius in prison and through a ruse tried to examine him. And then there was his first special parole officer who lied to him in order to try to get him to go to to see a psychiatrist. The fact of the matter is that private therapy, twice weekly, funded by him, no state involvement, okay? The therapist will report danger, and that would be that. He can have his GPS monitoring, and he's learned his lesson. He's been punished for it, for his violations, right? He served 3 months in prison. 6 weeks is our window here to transition him from home to his mother, to freedom, to fulfilling parole's goal of rehabilitation. Hopkins' fear has dictated his life for too long. And let's not steal these, don't let it steal these final steps for him to be able to transition to the community. You know, Mr. Cornelius, like all of us, he's not flawless. His views draw scrutiny in the mind of the Board of Paroles. His knives crossed the line. The searches stirred concern, but he's not a shooter. He's not a danger to the community. He's a man who's endured, you know, some significant punishment for literally for 24 years now. Okay, and Dr. Mills described him as low risk. What Hopkins saw was a myth. Okay, they created a myth of someone who's an active shooter. He's not an active shooter. He's not nearly an active shooter. There was never any violence or threats towards Hopkins. They have somehow turned themselves into the victims here, and they're not victims. And I don't see how the Board of Parole could consider them victims. Okay, revocation would bow to their fear. But it's not the reality. Therapy and oversight can guide him home to his mother, to a fresh start. I think he's earned that chance. And please don't let Hopkins's shadow take it away. And that's I think that covers what I'd like to say. But I also reserve the time to respond to the state.
Can I respond?
Sure, go ahead.
Okay. Number one, let's put this on the table regarding Hopkins School. The state Parole and Community Services has nothing to do with the Hopkins School. And we are bringing these charges and we are making the recommendation of a full revocation of parole based upon the evidence that we have gathered and have acquired. We have nothing to do with Hopkins School, and this is based upon our own evidence. Whatever Hopkins School does is what Hopkins School does. This is simply from the state. I find it very interesting that council, on one hand, calls our previous attempts to get mental health treatment for Mr. Cornelius a, quote, unnecessary psych eval, and citing another psych eval that was conducted that shows that Mr. Cornelius, you know, has no issues, yet they argue that the exact reason why we should allow him to be released early is because he needs mental health and he needs to go to treatment. And the reason why he is going to Board of Paroles members or staff members addresses is due to mental illness and some complications due to mental health. We really don't think that you can have it both ways. And so therefore, if Mr. Cornelius after May would like to seek mental health treatment, then I think that's a great idea. But in regards to these violations, I think council referred to it as a slip up. In Parole's world and what we do every single day, a slip up is using alcohol on one occasion. That's a slip up, and for that we issue a misconduct and we don't violate parole normally. This goes well beyond that type of quote unquote slip up. The looking up both staff at the Board of Parole and Parole and Community Services, going to their addresses, looking up the children of those individuals, and having a what can only be described as a cache of deadly weapons. It goes well beyond a quote-unquote slip-up. I agree that not everybody is flawless, as council just said. However, many people are perceived by individuals as having harm done to them by other people. Most individuals do not look up those people's children's and the street view of the addresses of which they work, nor do they go to the addresses of those individuals. So yes, not everybody is flawless, but I think that this goes well above and beyond. That's all.
Yeah, if I may respond to Supervisor Mann's points. Look, you know, I understand how the supervisor is looking at this. But again, this is clearly, the supervisor can't point to any violence because there was no violence. He can't point to any threats because there is no threats. And he can't point to any intent to do anything because nothing was done. The fact of the matter is that I'm not suggesting he has mental illness. I don't think Mr. Cornelius has mental illness. I don't think a psychiatric evaluation is necessary, but I think that he could benefit from therapy. And I think that the idea of someone, for Mr. Cornelius, who went through 14 and a half years of prison with a single, the most minor infraction you can imagine, okay, if someone is as dangerous as Mr. Cornelius is supposed to be, right? For him not to have not a single incident of violence, not a single incident of being involved in any sort of gang, not anything. Okay, he had a spotless record for 14 and a half years in prison. 14 and a half years. Most people don't get 14 and a half years for a non-violent offense, which is what Mr. Cornelius's offense was. And then for the 8.5 years on special parole, his record was spotless as well. I mean, so we're talking about here what I don't think that there's any evidence that goes beyond that Mr. Cornelius was collecting these knives. Now that clearly, according to the Board of Paroles, that violates the conditions of his parole, and we have to accept that. But the question is he was just put in jail for 3 months. And the question is do we want the next month and a half for him just to be sitting in jail and to threaten to damage the rehabilitation that he clearly has made and has shown? Or can't we deal with this constructively? That is what I'm asking the Board of Paroles to do. I think that Mr. Cornelius has earned that chance. You know, he's had great experiences with his last 2 parole officers, including his current parole officer and the parole officer before that. And he's been gradually, the degree of supervision has gone down to minimal supervision. And, you know, look, if we think, why don't we increase the level of supervision for the last month and a half? Okay, but let him out. Let's let him transition into the community in a way where we can build on his progress, where we can build on and basically address and basically have him address to, you know, go to therapy and deal with his issues in a more constructive way. And I think that he can. And I know that he can because I know Mr. Cornelius and I know his mother and I know the kind of person that Mr. Cornelius is. He's resilient, but a lot of people, I mean, I don't know too many people who have spent this much time in prison and then following that, a special parole for such a long time. And look how well he's done under it. He really has done very well. And for it to end this way, with him in jail, I think sends the wrong message. I think Mr. Cornelius has demonstrated that he can follow orders, that he has a lot of promise in him. He is artistic. He can do things. He can take care of his mother. This is something that that should be considered by the Board of Paroles in making a decision here. I really urge the Board of Paroles to let him be released. We can have it under moderate supervision at this point, and let him do what I'm asking that we do. That at his expense, he will seek therapy twice a week, and the therapist can report to the Board of Paroles if there's any concerns that the therapist has, and that's what I'm asking for.
Just,
And I
very,
thank you.
Thank you.
just very, very quickly. Council is correct that part of parole and community services is rehabilitation. It's a huge part of our mission statement and our mission in general. Beyond that, though, is our obligation to protect the public and protect the victims in all of our cases. And we have found enough evidence that we believe that protecting of the public goes beyond any type of rehabilitation that could be provided to Mr. Cornelius at this time. And therefore, that is why we ask for a complete revocation of his parole.
And if I could just say one thing, I don't want to, it doesn't need to keep going back and forth, but I just wanted to make one point, is again, that there's no sign that until until there was some, that Mr. Cornelius has been followed, he's been surveilled, and no one has noticed anything out of order here. I mean, Mr. Cornelius is not a danger to the community. He simply isn't. And there's no evidence of him being a danger. And so why don't we just end this on this term of special parole on a note where he's being helped where there's some assistance, where there's some guidance by the Board of Paroles to help him transition back, instead of having to spend another month and a half locked up in the jail. That's all I have to say.
Thank you. All right. So is there any additional information that we have not discussed yet that either side would like to save this time before I make a recommendation?
Well, all I can say, if there's some issue that I could address, I'd be happy to, because I have lived this case and know the history of Mr. Cornelius's case for the last 14 years. And so to the extent that I can address any points that the Board of Paroles is concerned about, I'm happy to do so.
I just want to clarify. So he would like to go back to his mother's. That's where he would be returning to.
Yes.
All right. So that would be his plan. Okay. In regards to, I know we discussed a lot about, we talked about public safety. We talked about each side has got to say their point on things. Is there anything additional from either side in regards to like release plan that we did not say yet?
No,
Okay.
For me. Thank you.
Okay, so I'm going to take a minute and I'm going to be right with you guys with my recommendation. So I do want to put on the record, I have listened to testimony on behalf of the state as well as council today on behalf of Mr. Cornelius. I will put on the record he was on supervision for about 9 years and 7 months before returning to custody for his first violation of parole, which is why we're here today. He did receive one misconduct in 2017. The state is recommending full revoke of the offender's supervision. He does complete supervision May 17th, 2025. as was noted by testimony today, it is concerning that this is some of the similar behavior that was why the offender was on parole, which includes having a large amount of weapons. As was noted by counsel, he has done well previously while on supervision for the amount of time he has been out. Based on the information that I have, as well as all testimony that I have listened to today, I am going to recommend that parole be revoked and that the offender remain incarcerated until a special parole completion date of May 17, 2025. This is an approximate 4.5 month sanction. My findings are going to go to the parole board on March 27th. The parole board has the opportunity, as I only make recommendations, the parole board makes the final decision. So on March 27th, the board is going to make the decision on whether or not they can agree with my sanction or they can let the offender out earlier. The earliest he can be let out is March 27th. They can let him out that day or any time in between the date of his end of special parole, which is May 17th. So he will receive this in writing from the parole board, what their decision is. About a week after March 27th, it will be mailed to him what the board's final decision is and if he will be given special parole conditions if he is reparoled. So he does have that definitely could happen. Do you guys have any questions or clarification?
Is there an opportunity to appear before the board before they make their final determination?
No, no. So the board will make that decision, as I said, on March 27th, and he will get it in writing what the decision is.
If I may, what information would be presented to the board? Is it just the finding, or do they get a recording of the audio?
Well, they're going to get a write-up of the summary, everything that you guys receive. They will get the summary of today's hearing, and then that's what they will be looking at. So if there's no further questions, this revocation hearing is concluded. So Mr. Cornelius, you're gonna get something in writing from the board. Okay, you get their final decision March 27th, well, a couple of days after that, probably.
Thank you, hearing officer. Thank you.
Thank you all.
Supervisor Mann.
Thank you.
Thank you.
I appreciate you guys.
Thanks.
Have a good day, everybody.
You too.
Thank you.
We'll put on the record inmate Aaron Velez, number 292593's preliminary hearing has been continued to March 31st. Morning.
Good morning. How are you?
Good, how are you?
Good.
Good morning. Sorry, you're muted.
Morning.
Good morning. I just have Mr. Hooks.
Yes, he'll be in here momentarily.
Great, thank you.
Yep.
And I know we're not on the record yet, but it is going to be a waiver.
Okay.
Yeah, I was just a little delayed in being able to speak with him, but I spoke with him shortly before the hearing.
Okay, no problem. I'll just introduce, go on the record, and then.
Perfect. Thank you.
Good morning. Mr.
Morning.
Hooks?
Yes.
Good morning. So I have your
morning.
attorney here. I'm just gonna go on the record. I know you spoke to your attorney before. Okay? Good morning. I am P.O. Meister, hearing examiner for the Board of Pardons and Paroles. Preliminary hearing, concerning Hooks Melvin, number 323721. Today is March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in Corrigan Correctional Center. This is a public hearing. Public access to the hearing is available via video live stream. Can you just state for me your full name and DOC inmate number?
Melvin Hooks, 323-721.
And you have counsel here?
Yes, for the record, Hannah Dean on behalf of Mr. Hooks.
And you put in a request. You said you'd like to waive, is that correct?
Yes, at this time, we are asking to waive the preliminary hearing. I know it's just a one count criminal violation, so we would like to waive it this time, and I will update once there is a disposition in criminal court.
Okay, so I'll accept the waiver of the preliminary hearing. Mr. Hooks, then we will see you upon disposition of those charges. We'll bring you back to determine if there's a violation, okay?
Okay.
Okay, so you're all set for today.
All right. Thank you.
Thank
All
you.
Talk to you soon, Mr. Hooks. Thank you. All
All right. Thanks.
right, I'll see you back at 11.
Thank you. Good morning. So you're muted, York.
Can you hear me now?
I can hear you.
Okay,
Perfect, thank you.
you're welcome.
Good morning, P.O. Shan.
Good morning.
Good morning, Ms.
How are you?
Castro.
Hi, Miss Castro.
Hi, how are you?
Good. How are you?
Hanging in there.
Good.
Mm-hmm.
Pushed it earlier, that's sometime, I think because we left and then.
Oh. We're here today for your revocation hearing. So we are going to get started with. You asked what? Are you ready? Good morning, I am P.O. Meister, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Castro Meiling, number 437864. Today's March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office, New York Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Meiling Castro 437864.
We have parole officer present today. Please identify yourself for the record.
Parole Officer Sheehan, Women's Reentry Unit, New Haven.
Thank you. We have counsel here today. Please identify yourself for the record.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Ms. Castro.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or one or more conditions of your parole, I will reinstate your parole, which is releasing and placing back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend a revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
Okay, important rights today. You have to have an attorney present and you have counsel here. You have a right to see the written notice of charge of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses, cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge, state your PO is bringing against you and the information underlying each charge. So PO Sheehan, please read the charges.
Sure. Charge 1 under curfew on 1/9/2025 at approximately 6:18 p.m. You walked out of Rise Halfway House and stated you were leaving the facility and not coming back to the program. You did not have permission from the halfway house or your parole officer to leave the facility. Your whereabouts in the community were unknown and you refused to disclose where you were to staff. This is a violation of Board of Pardons and Paroles release direction. Charge number 2, drug testing on 9/10/2024 or about this date, you rendered a urine sample positive for marijuana and fentanyl while at Rise Halfway House program. Based on your actions, you are in violation of release direction, obey all laws. On 10/15/2024 or about this date, you rendered a urine positive for marijuana and fentanyl while at Rise Halfway House program. Based on this action, you're in violation of release direction, obey all laws. Number 2, obey all laws. Charge number 3, obedience to the law. On 9/10/2024, you rendered a urine positive for marijuana and fentanyl. On 10/25/2024, you rendered a urine positive for marijuana and fentanyl. On 1/10/2025, you assaulted the case manager at Rise Halfway House while residing there. You were arrested on that day and charged with 53A182 disorderly conduct, case number 25-000-13407. Connecticut State Police gave you a summons with the arraignment date of 1/13/2025, and you were turned over to parole and remanded to York. That is a violation of the Board and Pardon Paroles, obey all laws. Charge 4, halfway house placement on 1/9/2025 at approximately 6:10 p.m. You walked out of the Rise Halfway House and stated that you were leaving the facility and not coming back to the program. You did not have permission from the halfway house staff or your parole officer to leave the facility. Your whereabouts in the community were unknown and you refused to disclose where you were to staff. On 1/10/2025, you assaulted the case manager at Rise Halfway House while you resided there. You were arrested on that day and charged with disorderly conduct. Connecticut State Police gave you a summons with an arraignment date of 1/13/2025. You were turned over to parole and remanded to your correctional.
Did you read the charge of drugs number 3?
Obey all laws, number 3.
Obedience to law and then obedience to law is charge 2. Charge 3, drugs.
You know what? I think she was served twice, so you may be correct that it did get updated.
Yes, it did.
So charge 2, obedience to the law is drugs. So 9/10/2024, on or about that date you
Charge
rendered
2
a
is
urine.
obedience to the law, and then you have the separate charge 3 drugs charges, which I have as the current one.
Okay,
Correct?
that is the current one, correct, yes. You want me to read charge 3 drugs?
Yes, please.
On 9/10/2024 or about the date you rendered a urine positive for marijuana and fentanyl while at Rise Halfway House program. Based on this your actions are in violation of release direction, obey all laws. On 10/15/2024, on or about this date, you rendered a urine positive for marijuana and fentanyl while at Rise Halfway House program. Based on your actions, you are in violation of release direction, obey all laws.
Thank you. And
It
the
was
state is all about, what was
I'm
that?
sorry, it was a fax copy that, and it's almost illegible. Sorry about
Yeah,
that.
no, it is hard to read. I understood, and you're right, with what you just read, so. And the state is all the following exhibits that are pre-marked for identification purposes as Exhibit A, signed statement understanding agreement, conditions of discretionary parole. B, Connecticut Board of Parole remand to custody order. C, notice of parole violation. D, parole violation report. E, notice of parolee rights. F, Rise Women's Program Halfway House Agreement. G, Rise Women's Program Residential Handbook, Acknowledgement and Handbook. G, Rise Women's Program, that's what I just said. H, Rise Program Incident Report for positive toxicology screening. I, Quest Diagnostic Drug Monitoring Report for positive fentanyl use collected 9/10/24. J, Misconduct for positive drug screen dated 9/18/24. K, Rise Program Incident Report for positive toxicology screening dated 10/22/24. L, Quest Diagnostic Drug Monitoring Report for positive fentanyl use collected 10/15/24. M, Voluntary Admission for positive drug screen dated 10/22/24. And Rise Program Incident Report for escape unaccountability dated 1/9/25. O, Rise Program Incident Report for assault on staff dated 1/10/25. P, misdemeanor summons premise appear bail dated 1/10/25. Open the record, exhibits Q and R were not, we were unable to view that, so that evidence has not been received and is not considered at today's hearing. Did you receive notice of parole violation report, and those other documents I marked? Did you review those?
Yes, ma'am.
And council's file the following exhibit pre-marked for identification purposes. That's exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. So at this time, the state is going to have an opportunity to call witnesses, present evidence, speak to any of the evidence submitted. I'm going to swear in P.O. Sheen as well as Ms. Castro in the event that you do want to speak today. Can you both please raise your right hand? You solemnly swear or solemnly affirm as the case and be the evidence you shall give, turn this case to be the truth, the whole truth, and nothing but the truth, so help you God, about penalty of perjury?
Yes, ma'am.
All right, so P.O. Sheen, would you like to say anything in regards to the violation?
I'm concerned that you didn't get an opportunity to see the the video. I was able to observe the video, and I was able to observe Miss Castro assaulting and hitting the staff member at the halfway house. So because you don't have the video, I wanted just to make it clear that I was able to observe it.
I know it's true.
Ms. Castro, please don't make any
And
comments.
I apologize for that.
Ms. Castro,
Yes?
please don't make any comments. Please do not comment.
No problem.
Go ahead, P.O. Sheen.
I just wanted to, because you weren't able to view the video, I wanted to make a statement that I did see the video.
Anything else you'd like to say, P.O. Sheen, in regards to the charges?
No, I think they speak for themselves other than that.
All right, turn over to council.
Thank you. No comment as to charge 1 curfew. In regards to charge 2, under the obedience to the law, just referencing paragraphs 9/10/24 and 10/15/24, we would submit there's insufficient evidence to support that charge, as the charge requires that the parolee was engaged in an act which is a crime. There's no allegation here that she was engaged in an act which was a crime. There certainly is not a Connecticut general statute referenced here as to which crime she was engaged in. Therefore, the defense could not properly defend against that charge. So we would submit there's insufficient evidence in regards to that. In regards to the paragraph 110/25, where the paragraph is characterizing my client's arrest as you assaulted the case manager. There's certainly no evidence here to support that there was an assault that took place. In fact, when the police did arrive, I imagine they had access to the same video that P.O. Sheehan is referencing, that we did not have a copy of for this hearing. However, they didn't charge her with an assault. They charged her with a disorderly conduct. And then again, she did go to court, and the court found it appropriate to allow the information for the state. I found it appropriate to substitute the information, which means that the original charge of disorderly conduct was removed and replaced with a charge of creating a public disturbance, which is an infraction. So again, we would submit there's insufficient evidence to support that portion of the charge. In regards to charge 3, I have no comments. In regards to charge 4, just referencing the paragraph of 110.25 again, it's characterizing assaultive behavior that there is no evidence of. And again, it references that the state police gave her a summons for disorderly conduct. And I would just again point out that that charge, the way the conduct is charged and alleged, it's referring to assaultive behavior. And there's no arrest that supports that there was an assault that took place. There's no evidence to suggest there was an assault that took place. And ultimately, my client was charged with an infraction. No further comments as to the charges.
Anything else before I announce my findings?
Nope.
I'll be right with you with my findings.
Mhm.
All right, so I'm going to announce my findings. So regarding charge 1, release direction curfew, I make a no finding. Due to the charge not meeting the elements, there's no evidence the offender had a curfew or what that curfew was. On charge 2, I find you violated conditional bail laws, obese law on part 3. This is based on evidence provided in support of the charge, which is Exhibit O, as well as testimony that was provided. Although the charge is slipped down, I do find the behavior meets the elements of the offense. A no finding is made on part 1 and 2, as that fails to meet the elements of the charge. On charge 3, I do find you violate condition bail laws drugs based on evidence provided, which is exhibits H, I, J part 1 and K and L on part 2. There is no finding on marijuana use, as that does not meet the elements of the charge of drugs. On charge 4, I do find you violate additional condition halfway house placement based on evidence provided, which is exhibits F and N on part 1 and F and O on part 2. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Sheehan, would you like to say anything this time regarding the seriousness of the offense?
Those particular 2 days were very out of character for Miss Castro. Other than those 2 days, she struggled with a lot of things, especially her medical situation. I felt like we had a very good relationship. We talked a lot. We met a lot. That particular day when she assaulted staff, when we came to get her, she also she refused to cooperate. She refused to speak. She attempted to trip me down the stairs multiple times. It was extremely out of character and very aggressive and violent. I was very, very concerned about her, very out of character for her. So it's really should be noted that not sure what happened. I do know that on her conditions, she has mental health, a stipulation for mental health, and if she were to be released again, I would like that to continue. She definitely needs to get back with the mental health treatment if she comes out again.
Thank you. Counsel?
Yes, thank you. Ms. Castro is 43 years of age. She's single. She does have 3 children who are adults, but she has received support, primary support from them, as well as her ex-boyfriend and a new girlfriend that she has. She does live with mental health issues, and perhaps she should be somebody that should be considered to be supervised by the mental health unit. I don't know if she presently is. She does suffer and live with substance abuse issues, which consist primarily of using marijuana. And so when you see the positive urine for fentanyl, she tells me that that was something that was in the marijuana. And so we had conversations about that she's not intentionally looking to ingest fentanyl, that she does utilize marijuana. She was in the community, I believe, for approximately 6 months prior to this violation. I believe this is her first violation of parole. She was released to discretionary parole on July 18th of 24, and she was placed at the Connection halfway house program in New Haven, and RISE program, and she was there until the date of her remand. During the time that she was in the community, she reports being successful in an IOP at the App Foundation, which I think, to her credit, shows that she was taking some initiative to try to address the issues that she was having. She was involved with counseling there as well, she tells me. She received medication management services as well. She was unable to find employment during this period of time. She tells me that she does have some outstanding medical issues and that she would like to apply for disability so that she does have some support, financial support when she is in the community. I would note that during the time periods that she's been in the custody of the Department of Corrections, not just referencing this particular period of time, which is only, I believe, approximately a little over 2 months, but just addressing her time in DOC as a whole, she does have an OAP that consists of 2 programs, and she's completed those 2 programs during her time period in DOC. So I think that's important to know that she is somebody that is with the structure, is on task, and does understand that she has those obligations and she's completed them. Upon being re-paroled in the community, she'd like to be placed in a halfway house again in the New Haven jurisdiction. She is agreeable to all treatment recommendations. She would like to obtain her GED, apply for disability, and establish primary care services in the community so that she can address her medical issues. We would be asking, based on the totality of circumstances, but I think primarily what we're seeing here is that the behavior and the conduct, I think P.O. Sheehan also touched on this, kind of occurring around the same period of time, was out of character for her, and that it is directly related to substance abuse. And so certainly she could benefit from being in the community and receiving those types of services. And so we would be asking that she be re-paroled at the next available date. Thank you.
Thank you. Anything else, or anyone else before I make a recommendation?
No, ma'am.
Yeah, can I just say
Yeah.
one thing?
Go ahead.
I did check on her when she got to York, and her urine was negative for illicit substances on that day. So was really perplexing for me because of her behavior. I thought originally that it would have been maybe some substance use, but she didn't have substances when she got to York. So it definitely stands out to me as some sort of a mental health issue. So I think it's really important to point that out because that's really what was going on for her, I believe.
Thank you.
And I can just note that during her time period in DOC, I believe that she has been medication compliant. So I think that helps address some of that issue.
I'll be right with you with my recommendation. So I have reviewed all the evidence provided as well as listened to testimony today. I will put on the record, offender was only in the community for about 5 months and 23 days before she was returned to custody on new charges, which were I do want to put this on the record. The addendum did report on 2/11/25. The charge was up to the infraction of creating public disturbance when she received a $50 fine for that charge. She does have a prior failed community supervision in the community. She is currently serving time for violation of probation. She does have 5 years probation to follow this period of incarceration. Based on the information I have, I am going to recommend that parole be revoked. You be re-paroled for May 9th, 2025. It's about a 4-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, preferably, you said in New Haven, is that correct? New Haven?
Yes.
Mental health evaluation and treatment as deemed necessary, as well as behavior management program for anger management. My findings are going to the parole board March 27th. So the board's going to make the final decision. They can lessen the sanction, let it stand, or impose a sanction longer than what I've recommended. If they would like a longer sanction than what I've recommended, you'd have a supplemental hearing. And before the hearing, the board would provide you with written notice documenting the reason why they may want to exceed my recommendation. And during that hearing, you would have an opportunity to respond to those reasons in front of the panel of the board. So that is only in the event that they would like to hold you in longer. Do note the board can revoke all of your parole.
Yes.
And I recommend you get involved in treatment as soon as you get out there to continue with what you're doing inside.
Yes, ma'am.
So I wish you the best of luck.
Thank you very much.
Thank you to both sides.
Thank you.
All right,
Thank
thank
you.
you. Thank you.
Have a good day, guys.
You too.
Bye, Ms. Castro.
Bye.
Morning. Oh, you're muted.
Can you hear me now?
I can hear you. Yes.
All right, thank you.
Thank you. Mr. Hill?
Yes.
Morning, sir.
Morning.
We're here today for your revocation hearing.
Yes.
So we'll get started with that in 1 minute.
Okay.
Good morning. I am P.O. Meissner, a hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Hill Zera number 122851. Today is March 19, 2025. This hearing is being conducted via video at the BOPP Central Office in MacDougall Walker Correctional Institution. This is a public hearing and public access hearings available via video live stream. Can you please state your full name and DOC inmate number for the record?
Ezra Hill, 122851.
You have counsel here today. Please identify yourself.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Hill.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. State, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have opportunity to present all relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay, you have important rights today, the right to have an attorney present, and you have counsel here. You received the written notice charged the violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you, right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge, state your appeal is bringing against you, and information underlying each charge. Charge 1, obey all laws, obedience to the law. You're charging off support at 11923. You attempted to illegally enter a private residence in the city of Stamford by standing on a garbage can, opening a window, and forcibly breaking the screen with residents occupying the address. A resident shouted at you to stop, but you continue to attempt to enter the residence. You were subsequently arrested by Stamford PD and charged with attempted burglary second and criminal mischief third. We'll put on the record, I did receive an addendum from PCS. The addendum reported on 2/19/25. You were convicted of attempted burglary second, as well as criminal mischief third. You received a 2-year jail sentence for attempted burglary second and unconditional discharge for criminal mischief third. I have an EOS date on that sentence of 2/19/25. So that sentence has been completed. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, Connecticut conditions of parole; B, remand of custody; C, notice of parole violation, employee rights; D, parole violation report; and E, a Stamford PD incident report ending in 0020. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes.
And council's filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue sharing to obtain any additional evidence?
No.
We have no witnesses today. So it's not a defense opportunity if you'd like to speak to any evidence submitted.
Yeah, thank you. I would just indicate that in regards to charge 1, the addendum is stated correctly. His EOS date was listed as 2/19/25, but I would just like to point out that that's the date he pled in court. So he actually completed the 2-year sentence on January 23rd of 25. However, he didn't go to court until the 19th, and that's the date that he entered the plea. So he was over the 2 years in jail at the time that he entered into his plea agreement, and he's been held now for 26 months. Nothing further as to the charges or charge.
So what I'm gonna do next is announce my findings. So on that charge one, I do find you violated the conditional bail law, obedience to the law. This is based on your conviction of attempted burglary second, received a sentence of 2 years jail, and criminal mischief third, and received an unconditional discharge. This concludes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, thank you. My client is 58 years of age, single. He does have one adult child who resides in Bridgeport. He's a high school graduate of having gone to high school in Stamford, Connecticut. He indicates to me that he received some drafting certifications at Stamford, at Rye Technical School as well. He was in the community for approximately 6 months prior to this violation. During the time period that he was in the community, he utilized the Isaiah Halfway House program and participated in programming through that house. He also sponsored and lived with his brother, Tony Brooks. He supported himself with disability because he does suffer from Parkinson's disease, which he was diagnosed with approximately 3 years ago. He also worked part-time for an irrigation company in Stamford. He's been in the custody of corrections now for approximately 26 months, having received a 2-year court sentence. I would note that his parole officer did recommend that his parole be revoked and that he re-parole at the end of his court sentence. He indicates upon parole reinstatement he'd like to sponsor to his mother's house, and her address and information is contained within Defense Exhibit 1. He also provides a second choice sponsor, who is his niece, and her information is also contained within Defense Exhibit 1. He would like to reestablish his disability when he's released back into the community, as well as to be available to assist his mother. He's amenable to all treatment recommendations, and he would also like to reestablish his primary care to address his needs, as he does suffer from a significant medical issue. I believe he has approximately 14 months left on parole. We would be asking that he be re-paroled at the next available date. I believe that's in line with what his parole officer's recommendation was. And again, he's served in excess of 2 months in excess of his 2-year court sentence. Thank you.
Thank you. So I was testimony today, and I have reviewed all the evidence provided by the state. I will put on the record, this is the offender's first violation on this period of supervision. I see no noted misconducts. He did complete this sentence February 19, 25, which received a 2-year jail sentence for attempted burglary second. He does have according to our records, has failed 6 out of 10 prior releases to community supervision. And he was on parole about 8 months before he was returned to custody on these new charges. The parole officer did recommend re-parole as well as halfway house placement. If you were placed in a halfway house, what area would you want to go to, sir?
I would go to Bridgeport.
Okay. All right, so based on all this information, I'm going to make a recommendation. I am going to recommend that parole be revoked to be re-paroled from March 27th, 2025, but a 2-year, 2-month period of confinement as a sanction. This is my next available board review date that I have. I recommend the following conditions. This is halfway house placement. That's only event you can't go to the sponsors, but your officer did recommend halfway house placement upon re-parole. So that's why I'm putting it in there. No consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, and no contact with your victims, CEM and TZM. My findings to go to the parole board on March 27th. If the board agrees with me, you would be released that day. So you'll know they agree with me if you're released on March 27th. If you're there past March 27th, that means the board decided they wanted a longer sanction. And then you get a notice in the mail indicating the reason why. Then you would come before the board for a supplemental hearing, and the board would discuss with you why, if they would like the sanction longer. So just so you know, that is an option for the parole board. Do you have any questions?
No.
Okay, then you are all set for today, sir, and I wish you the best of luck.
Okay, thank you. Thank you.
Have a good day.
Thank you.
Good morning. You're still muted. Thank.
Can you hear me?
Yay! Yes.
It's been so delayed. I don't know what's going on with it, but I have Irizarry here for you.
Thank you so much.
You're welcome. Irizarry? You right here in this room. We can have a seat here.
Hello, hello.
Good morning, sir.
Good morning, good morning.
We're here for your rev hearing today, so I have your attorney here, so we're going to get started, okay?
Okay.
Good morning, I'm P.O. Meisinger, I'm here an examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning Irizarry Lewis, number 297854. Today is March 19th, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing, and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Alex Vasquez, formerly known as Louis Irizarry, inmate number 297854.
Thank you. When you have counsel here today, please identify yourself.
Yes, good morning. Hannah Dean on behalf of my client, Mr. Irizarry Vasquez. Good morning, sir.
Morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing you, place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure before we begin?
No, Your Honor.
Your important rights at this hearing, which I will now review with you. Right to have an attorney present. You have counsel here. You right to receive the written notice of charges of violation. Do you receive the written notice?
Yes, Your Honor.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and you're ready to go forward?
Yes, Your Honor.
All right, so now review the charge. Is that the state your PO is bringing against you? Any information underlying each charge? I will put on the record charge 2, charge 3 are not taken into consideration as a no finding was made at the time of the preliminary hearing and there is no new evidence provided by the state. So charge 1 under release section GPS, you're charging officer reported 10/16/24. The offender signed the GPS monitoring agreement and was instructed 137 New Lab, Bristol, Connecticut is an exclusion zone and he is not to be at that residence due to his minor son residing there. On 11/23/24 from 3:42 p.m. until 5:16 p.m. the offender was at the exclusion zone residence. The offender violated the GPS monitoring agreement, which states, I will abide by all established inclusion zone requirements or exclusion zone requirements and must obtain prior permission from a PO prior to changing any established zones. Charge 4, no contact with minors. Your charging officer reported 119/25 New Britain PD was dispatched to the offender's residence at approximately 5:38 a.m. on a report that the offender pepper sprayed his roommate because the roommate woke up the offender's minor son. New Britain PD responded, smelled pepper spray, but could not determine who sprayed the roommate. New Britain PD stated the offender left the residence with his minor son. Therefore, the offender has in-person contact with a minor child without express permission of his parole officer. Charge 5. Parole officer reported on 12/23/24. The offender signed updated parole conditions with this condition added. The offender was instructed if he wants a device that has access to the internet, he will need to have monitoring software installed. On 1/24/25, the offender was found in possession of the tablet that did not have the monitoring software installed. The offender's screen time analysis shows he utilized the tablet from 1/5/25 to 1/24/25 for a total of 102 hours and 33 minutes. The offender created a Facebook page with the profile name Tortuga Trickster and Discord page with the profile name Officer Tortuga Vasquez. Charge 6 under problem sexual behavior treatment. Reporting officer stated on 7/16/24, the offender signed the CTPSV treatment agreement in which he acknowledged he is restricted from contact with children under 16 unless recommended by CTPSV staff and approved in advance by his supervising officer. On 1/19/25, New Britain PD was dispatched to the offender's residence on a report that the offender pepper sprayed his roommate because the roommate woke up the offender minor's son. New Britain PD responded, smelled pepper spray, but could not determine who sprayed the roommate. New Britain PD stated the offender left residence with his minor son. The offender violated CTPSV treatment agreement by having unapproved contact with his minor son, which resulted in the offender's unsuccessful discharge for problems with behavior treatment. It should be noted the offender's legally changed his name to Ellis Vasquez, which is why the police report does not list Louis Irizarry. And the state has filed the following exhibits pre-marked for identification purposes as well, these were stated at the time of the preliminary hearing. We don't need to restate them. There are no changes to the evidence that was submitted by the state. Did you receive notice of parole violation report, and those other documents that we marked at the preliminary hearing?
Yes, Your Honor.
Yes.
And counsel has filed the following exhibit pre-marked for identification purposes. That's exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
We do not.
Okay, we don't have any witnesses today. So it's now defense's opportunity, if you'd like to present any evidence, speak to any of the evidence submitted at this time, May.
Yes, thank you very much. So I just wanted to clarify, you said that you were not considering charge 2, that was a no finding?
Correct, charge 2 and charge 3.
Okay, thank you very much. So I'm going to just refer throughout to my client as Mr. Vasquez, but just as it is known, he was formerly known as Louis Irizarry. I just wanted to clear that for the record. So as to the first charge of GPS, I would argue that the preponderance standard has not been met. Although the GPS agreement is an evidence and the event history, we don't have any exclusionary zone maps that have been submitted to evidence, and the GPS event history doesn't actually show the client's GPS points on the map. So I would argue that it's unclear based on the submitted evidence whether my client was on notice of the specific exclusionary zone from which he had to stay away. So I would argue that the evidence is insufficient for that specific charge. As to charge 4, no contact with minors, and charge 6, I would say, because it's similar conduct for each. My client indicates that this contact was in no way intentional, and he was not alone with his son at any point, as his son did not stay the night. He indicates that his sister was watching his minor son. On the way back to drop the son off, she was passing through his side of town and had to use the restroom. She, my understanding is, did not disclose to my client that his minor son was with her. And my client thought, okay, she's just stopping by quick to run up and use the restroom. My understanding is that she came upstairs and did bring the child, but my client was not apprised of the fact that she would be bringing the child there. So in no way is that intentional conduct. I would argue that the standard has not been met there. As my client was not noticed that this was a concern. In addition, I also just want to put on the record that a DCF referral was made on the date of this alleged incident, 1/27 of this year, regarding the allegations of my client having contact with his minor son. And I will just note, as the commissioner of the Superior Court, I do owe a duty of candor. So I will state that I did receive records from DCF. Due to the confidentiality, I did not ask that those be put in evidence, but I give my word as a commissioner of the Superior Court, I obtained those records. And the case was actually closed out on March the 10th, and there was no substantiated allegations. Specifically, the closeout note states, at this time, there were no needs that are not being addressed for the child. He appears to be doing well. There were no safety concerns identified during the investigation. The allegations were unsubstantiated. So I did just want to clarify that for the record, that DCF, which I would argue is maybe the more appropriate entity to be considering these issues regarding child welfare, did do an internal investigation and they found nothing to be substantiated. So I did just want to clarify that. As to charge 5, the enhanced internet and device monitoring, I would argue for that the preponderance standard hasn't been met. I understand that there are some images and evidence and that the allegations are my client had potentially access to these devices. However, it's unclear based on the information that's been submitted as evidence whether it was actually my client himself who was accessing these devices. And in fact, I know that at least one occasion, I believe, his wife had actually called to put Parole on notice that she was the one accessing some of those matters on the device. My client has been clear that those devices were not his. They were left there inadvertently by his wife. He was not accessing them. He was not accessing these things. So I just want to make that clear. So those are the comments that I have as to the actual charges. And at the appropriate time, I would like to remark on his background and future plans. Thank you very much.
Thank you. I'll be with you with my findings. So I am going to announce my findings regarding that charge 1. I do find you violated condition GPS based on evidence that was provided in support of the charge, which is exhibits B, C, G, L, and O. Regarding, as I said before, charge 2 and 3 are not taken into consideration today. Charge 4, I do find you violated that condition, no contact with minors based on evidence provided, which is exhibits B and M. On charge 5, I do find you violate condition enhanced internet and device monitoring based on evidence that was provided in support of the charge, which exhibits B, C, G, K, and N. And on charge 6, I do find you violate condition problem sexual behavior treatment based on evidence provided, which is exhibits B, F, I, and M. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you very much. My client, Mr. Vasquez, is 39 years old, born and raised in the Waterbury area. He receives his primary source of support from his wife, Genny Vasquez, his sister, Betty, his sister, Shakira, and his best friend and supervisor from a previous job, Mr. Matthews. He also gets support from Mr. Matthews' adult son as well. My client and Ms. Vasquez do have one son together who was born last year in March. Most recently, upon release to special parole supervision, my client successfully completed Renaissance Central Halfway House and was then self-sponsored at an address in New Britain where he remained until his remand. Previously, while on supervision, my client was released in January of 2020. He utilized from January until April the January Center, successfully completed that, and then was sponsored by himself and then his wife for a period of time prior to the birth of their son. He was reportedly interested in enrolling in adult education at that point to get his GED and further his education. He previously worked for Emily's catering group out of Bristol and was actively searching for additional employment. He reports that he had obtained a position at McDonald's, though was eventually denied the opportunity to work there due to there being a playscape there. However, he had obtained that position and was looking forward to starting. In January of 2025, the 14th, my client completed an intake assessment at the AIC program through Wheeler in New Britain. He participated in the reasoning and rehabilitation group on January 24th of this year. He also did the Connection Center CTPSB program and was reportedly in phase 2 at the time that he was remanded. May 8th, 2020 until October 21st, 2020, he had successfully completed the CTPSB program. We got documentation saying that he was attending consistently, was engaged and doing well in treatment there. He also reports attending outpatient services at CHC in Hartford, including medication management. My client is registered with the Sex Offender Registry, is compliant. Since his incarceration, he reports medication compliance. He's had no disciplinary issues, and he also reportedly wrote to Addiction Services and Mental Health for programming. Upon reinstatement of my client's special parole, he would like to be placed in an apartment through Chrysalis Center in Hartford. Should he be placed in the halfway house, he's requesting, I believe, the Hartford jurisdiction. Is that correct, Mr. Vasquez?
Yes, ma'am.
Thank you. He's also hoping to enroll in adult education to get his GED. He's open to any sort of work recommendations, and also he's open to any sort of treatment recommendations, including doing the medication management, doing the CTP-PSB program, and anything else that's asked of him. I would argue that these are technical violations only. My client got no new criminal charges for these allegations, despite involvement of police allegedly for that incident in January. He has absolutely no disciplinary issues prior to that. He's been on supervision since 2020. This is only his second violation. My understanding is that prior to the first violation, he was doing absolutely phenomenal in the community, had no even DRs or incidents from that period. He was only remanded once before for a failure to register that I do not believe was intentional. I believe it was a mistake, and he did resolve that. I will just note from speaking with both my client and his wife, it appears that there were a number of concerns regarding his parole officer here, which are very unfortunate. Specifically, my understanding is when his wife got pregnant, they were very excited about this news. My understanding is that the PO actually told them, you didn't have permission to have a child, which, you know, I think is a little bit crazy. My client, I believe, has been doing absolutely everything that he needs to do in order to go through the correct channels to, you know, address potential contact in the future with his child. However, he has not been trying to circumvent that process. My understanding from him and his wife is that they've gone through the process a number of times, submitting the appropriate paperwork, and felt as though they were submitting it to the PO to no avail. There were a couple times, I believe, when they contacted either program personnel or victims advocates to determine, okay, have you gotten the paperwork? And they were told on those occasions they hadn't even received it. So I think, you know, it has been somewhat frustrating for both my client and his wife, because they're trying their hardest to do the right thing. I mean, he is somebody who's been on parole for quite some time, has really not had any issues. I don't believe he's an issue in the community. He's been putting his head down and doing what he needs to do as far as treatment goes in order to move forward. I would argue that my client should not be given a sanction to exceed 2 months. He's already been incarcerated for about 2 months at this point. Again, these are technical violations. He has been trying his best to go through the right channels. So that would be my argument as to Mr. Vasquez, and I'm asking for a sanction not to exceed 2 months. Thank you very much.
Thank you. So I'll be right with you with my recommendation.
Thank you.
So we'll put on the record, after listening to testimony and reviewing all the evidence provided by the state, I will note the offender was on special parole for about 8 months before he was returned to custody on this violation. He does have a prior criminal violation in which he received a 7-month sanction. He has received 3 noted misconducts on this period of supervision. He does have, according to our records, 1 failure on community supervision on a prior supervision. He's serving 10-year special parole with an end date of special parole in January of 2030. The PCS officer is recommending a 1-year incarceration. I do take into consideration findings made today, as well as no findings that were made at the time of the preliminary hearing. Based on the information that I have, as well as all the testimony, I'm going to recommend that parole be revoked to be re-paroled for August 25th of 2025. This is about a 7-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, restriction on pornography, behavior management program for anger management, no contact with your co-defendant Terrence Ortiz or Lester Quinteros, no contact with your victim MJ or LI, enhanced internet and device monitoring, mental health treatment and medication compliance, no contact with minors without PO's permission, and problem sexual behavior treatment. My findings are going to the parole board on March 27th. The board's going to review this. The board can lessen that sanction, let it stand, or impose a sanction longer than what I have recommended. If the board wants to impose a longer sanction than what I've recommended, you'd have a supplemental hearing. The board will let you know the reason why they would want it, and then you'd appear before them for that hearing if they do want to exceed my 7-month recommendation. Do you have a question, sir?
No, but all I can say is that I'm just trying to go home to my wife. I've been doing everything that necessary to at least be the father that I never had, but I'm being restricted and prevented from doing so. I've been through the process. I've done everything necessary to be home, to behave, I haven't even been violent, no violence at all. And I have a history of violence. I've controlled myself. I've been peaceful. I've been honest. Okay, maybe a lot of people may think I'm an asshole, excuse my language, because of my honesty, but that's just me being honest. A lot of people don't like it, but honestly, not my problem, At least I'm being honest.
Okay.
Would you rather have somebody honest than lying?
No. I understand what you're saying. I understand you expressed your frustration for going through processes and not happening as fast as you like. So I do understand that, but you still have to go through the process. I hope this time that this process works out faster for you. I don't know what, I just hope everything works out well for you when you go back out. Just be patient with the process and do things the right way so you don't come back here.
I'm trying my best. I'm doing my best, It's just a lot of people don't see.
That's why I understand that, and that's why, I gave you the sanction that I did give. And I hope that you do well out there. And we do recognize that you do, you are doing things right, but things happen that were, shouldn't have happened. And learn from this and move on and, pick up, do things to the right procedure with your whoever officer you get. And hopefully you can have contact soon, permission. So I wish you the best of luck, sir.
Alex, I'll set up a legal call with you for the date of the board review so that I can update you on what they decide. And I can also update your wife as well if she has any questions about what happened, okay?
Please, thank you so much.
All right, thank you very much. I hope you have a wonderful day. Thank you.
Okay, so you're all set today, sir. I wish you the best of luck. Thank you to both sides. Thank you, Attorney Dean.
Thank you. Thank you so much, Alex. See you soon.
Yes, ma'am.
Opportunity to be free.
Your 2
from
minutes
the
has
consequences.
elapsed. Please conclude your statement.
Sure, yes, ma'am. Someone who deserves to be freed from some dramatic decision by the governor from the consequences of his crime, we would urge a negative report on Mr. Bruno Martinez's petition for executive clemency. Thank you.
Thank you. If you would like to speak in opposition to Joseph Bruno Martinez and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Joseph Bruno Martinez, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Joseph Bruno Martinez? Is there anyone else who has not spoken who wants to speak about Joseph Bruno Martinez? Chairperson, there appear to be no more speakers for Joseph Bruno Martinez.
All right, thank you. Mr. Gonzalez and Mr. Ramirez, you're welcome to stay for the entire hearing, or if you'd like to excuse yourself now, you surely may. Thank you. That his case has been completed for the testimony. All right, the next case is David Fitz. K as in King 14129, item 27. Moderator, please call for speakers in support.
Thank you. If you would like to speak in support of David Fitz and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in support of David Fitz, please unmute yourself by pressing *6 and identify yourself. Is there anyone who would like to speak in support of David Fitz? Chairperson, there appear to be no speakers in support of David Fitz.
All right, we'll now call for speakers in opposition to David Fitz.
Thank you. We do have a speaker card, Julianne Walker, DDA of Los Angeles County. Julianne, if you're with us, go ahead and unmute yourself. Your 2 minutes starts when you begin to speak. Julianne, if you're speaking, we cannot hear you.
I'm sorry. There we go. All right. Good morning. This case should not be recommended for the largesse of the governor's commutation power. It's perhaps appropriate for Innocence Project or LADA Conviction Review Unit to investigate inmates Fitz's claims of innocence and wrongful conviction. The jury's verdict has been upheld on appeal. His habeas petitions and resentencing motions have been denied. Thus, making Fitz eligible for parole will be focused on his implausible denial that he killed one man and seriously wounded another in a gang turf robbery. He was also tried but acquitted in a prior robbery murder where a produce truck driver was shot in the head. The trial court recently ruled on July 25, 2024, that he was a direct perpetrator, aider and abetter, and alternatively, a major participant in the murder and attempted murder in the course of the robbery, and thus he was not eligible for resentencing. What makes his implausible denial particularly unsound is the inmate's claim in his application that law enforcement planted fingerprints in order to prevail or lied at the preliminary hearing about it. This doesn't explain how he was convicted by a jury, and all of his appeals have been denied. The LADA office is opposed to commutation of Fitz LWOP sentence as he has not engaged in genuine pro-social rehabilitation since he's not accepted responsibility for his actions and therefore is lacking insight due to his denial. He continues to engage in criminal thinking and remains a current and unreasonable risk to public safety. Thus, we request that you deny approving his recommendation for commutation. Thank you.
Thank you. If you would like to speak in opposition to David Fitz and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to David Fitz, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to David Fitz? Is there anyone else who has not spoken who wants to speak about David Fitz? Chairperson, there appear to be no more speakers for David Fitz.
All right, the next case is Andrew Clark, F as in Frank 59288, item number 28. Moderator, please call for speakers in support.
Thank you, Chairperson. If you would like to speak in support of Andrew Clark and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in support of Andrew Clark, please unmute yourself by pressing *6 and identify yourself. Is there anyone who wants to speak in support of Andrew Clark? Chairperson, there appear to be no speakers in support of Andrew Clark.
All right, we will now take speakers in opposition to Andrew Clark.
Thank you, Chairperson. I have a couple speaker cards. The first is Dino Paraskevopoulos. I'm sorry if I mispronounced the last name. DDA of San Diego County. Dino, go ahead and unmute yourself. Your 2 minutes starts when you begin to speak. Dino, if you're speaking, we cannot hear you. I will circle back. The next is John Oliphant, DDA of Riverside County.
Good morning.
John,
Can you hear me?
Yes, we can. Go ahead.
Fabulous. Good morning. My name is John Oliphant. I'm a Riverside County Deputy District Attorney. This panel meets this morning to consider en banc new confidential information provided pursuant to a BPH-directed investigation. Mr. Clark has been in the medically assisted treatment program for over 2 years. He says he doesn't have an opioid addiction, and he hasn't used opioids his entire prison term. He admits that he lied to get into the program at the suggestion and complicity of medical staff. At his hearing, he claims his doctor and the MAT staff know that he does not have an addiction and have kept him in the program anyway. He gets Suboxone in sublingual form and takes it daily. These troubling allegations were the subject of this investigation. The results of that investigation have been shielded from scrutiny under the confidentiality statute pertaining to institutional safety. Surely the entirety of the inquiry is not subject to confidentiality, and we urge this body to provide transparency in this matter. Suboxone is an opioid developed for treating addiction to opioids. It is not approved by the FDA for pain relief. I quote from the literature, Suboxone sublingual film is not approved by the FDA for use as a pain relief medication. The inmate's allegations raise serious issues that go beyond the inmate's readiness to parole, and it's our hope that these allegations will be openly addressed. Thank you, panel.
Thank you. If you would like to speak in opposition to Andrew Clark and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Andrew Clark, please unmute yourself by pressing *6 and identify yourself. We have a hand raised, John Cross. Go ahead.
Yes, I spoke with Dino from my office. He's having some connectivity issues, so he should be on shortly.
Thank you, John. If you're on the phone and you want to speak in opposition to Andrew Clark, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Andrew Clark? Is there anyone else who has not spoken who wants to speak about Andrew Clark? Chairperson, there appear to be no more speakers at this time for Andrew Clark.
Yeah, agreed. Mr. Paraskopoulos, you are not present, sir. All right, then we will move on and come back to that at the end of our calendar. The next case is Justin Flournoy, K King 24068, item 29. Moderator, please call for speakers in support.
Thank you. If you would like to speak in support of Justin Flournoy and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in support of Justin Flournoy, please unmute yourself by pressing *6 and identify yourself. Is there anyone who would like to speak in support of Justin Flournoy? Chairperson, there appear to be no speakers in support of Justin Flournoy.
We will now take speakers in opposition to Justin Flournoy.
Thank you. If you would like to speak in opposition to Justin Flournoy and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Justin Flournoy, please unmute yourself by pressing *6 and identify yourself. Is there anyone who would like to speak in opposition to Justin Flournoy? Is there anyone else who would like to speak about Justin Flournoy? Chairperson, there appear to be no speakers for Justin Flournoy.
All right, the next case is Isaac Romero, V as in Victor, 28806, item number 30. Moderator, please call for speakers in support.
Thank you, Chairperson. If you would like to speak in support of Isaac Romero and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in support of Isaac Romero, please unmute yourself by pressing *6 and identify yourself.
How do you press *6?
Go ahead.
Can you hear me?
Yes, we can.
Hi, this is Rose Alma Romero, the daughter of Isaac Romero, here to speak on support. I just wanted to state that my dad has been doing a great job with his rehabilitation and all his classes. I've been by his side along the whole time, and I just wanted to, that's like it.
I'm sorry, you appear to be muted, ma'am.
Hello?
Yes, go ahead.
Sorry, I was just having technical difficulties.
Please continue.
Again, he's been doing great with all his work, and that I support him and everything that he does, and he's just doing amazing. Sorry, it's trying to speak. And I think that's where I'm going to conclude it. Thank you.
Thank you. Is there anyone else who has not spoken who would like to speak in support of Isaac Romero? Chairperson, there appear to be no more speakers in support of Isaac Romero.
We will now take speakers in opposition to Isaac Romero.
Thank you. If you would like to speak in opposition to Isaac Romero and are on video, raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Isaac Romero, please unmute yourself by pressing *6 and identify yourself. Is there anyone who wants to speak in opposition to Isaac Romero? Is there anyone who would like to speak about Isaac Romero? Chairperson, there appear to be no more speakers for Isaac Romero.
The next case is Frederick Willis, K as in King, 67955, item number 31. Moderator, please call for speakers in support.
Thank you, Chairperson. If you would like to speak in support of Frederick Willis and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you're on the phone and you want to speak in support of Frederick Willis, please unmute yourself by pressing *6 and identify yourself. Is there anyone who would like to speak in support of Frederick Willis? Chairperson, there appear to be no speakers in support of Frederick Willis.
We will now take speakers in opposition to Frederick Willis.
Thank you, Chairperson. We have a speaker card for Julianne Walker, DDA of Los Angeles County. We know you're here. Go ahead, Julianne.
Good morning again. In this matter, the inmate shot his wife in the head, apparently in jealousy over her infidelity. The victim suffered some permanent brain damage. He had just been released from prison for a conviction of a criminal threats PC 4/22, wherein the same victim was threatened. In that incident, he had also fired a shotgun. Her suspected infidelity had been the issue in that case as well. The new confidential information in this matter clearly shows on video that the inmate got angry, stood up, and threatened to kill another inmate. He had to be restrained by other inmates and convinced to sit back down. Though both inmates deny any animosity towards one another, it is obvious Willis continues to have anger issues that are connected to the life crime. Thus, this grant should be set for a rescission hearing, so this recent display of anger and failure to use his coping skills he should have internalized to calm himself can be addressed, and the panel can determine whether or not the grant should be, in fact, rescinded. Thank you.
Thank you. If you would like to speak in opposition to Frederick Willis and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Frederick Willis, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who would like to speak in opposition to Frederick Willis? Is there anyone else who has not spoken who would like to speak about Frederick Willis? Chairperson, there appear to be no more speakers for Frederick Willis.
The next case is Benny Espinoza, V as in Victor 90095, item number 32. Moderator, please call for speakers in support.
Thank you, Chairperson. I have a speaker card for Brandon Lee. Looks like San Jose Public Defender's Office.
Thank you. My name is Brandon Lee. I'm a Deputy Public Defender at the Santa Clara County Public Defender's Office. My office has been working with Mr. Espinoza since 2022, and I've been regularly meeting with Mr. Espinoza about his youthful offender parole over the past year. First, to address the issue of restitution fraud, I confirmed with the Office of Victim and Survivor Rights and Services that Mr. Espinoza paid off direct victim restitution in full 7 years ago in 2018. The circumvention of restitution that occurred here was on a restitution fine, which is no longer being collected under AB 1186. Also, Mr. Espinoza took responsibility for the circumvention of the restitution fine at the parole board hearing and indicated approximately when he had discontinued that circumvention. He has otherwise shown a commitment to paying restitution and expressed insight into the importance of paying restitution. Regarding the governor's referral, Mr. Espinoza has an extensive support network. I believe you'll hear from several individuals this morning, including our re-entry specialist, who will describe the support Mr. Espinoza will have upon his release on parole, including access to housing, employment, and sponsorship. Mr. Espinoza has taken responsibility and demonstrated remorse for the commitment offense. His personal history of growing up in an abusive and neglectful environment substantiates the existence of youthful offender factors. He's shown extensive insight into his causative factors and a capacity to change, and he has demonstrated complete separation from gang involvement. We are requesting that the board affirm his grant of parole. Thank you.
Thank you. If you would like to speak in support of Benny Espinoza and are on video, please raise your hand with the Microsoft Teams button, and I'll call on you when it is your turn to speak. We have a hand raised. Ana Jimenez, go ahead. Your 2 minutes starts when you begin to speak.
Good morning, Commissioners. My name is Ana Jimenez. I'm an outreach specialist with the Office of the Public Defender, Santa Clara County. I'm here to support Mr. Benny Espinoza's release. In my position, I work closely with public defender clients to help create intentional reentry plans to help our clients thrive in our community upon release. As an advocate for our clients, I work directly with agencies and services that help our clients have a successful reentry transition. Mr. Espinoza and I have known each other for about a year, and we have met and spoken regularly Throughout all the adversity of his life, and including a challenging upbringing, Mr. Espinosa has maintained a positive attitude and outlook into his future. He has been committed and determined into his rehabilitation. His commitment to prepare for his release has given him an abundance of options for transitional housing, employment options to help secure his immediate needs. He has a solid support system, which includes his wife, Dolores Espinosa, and their children, his sponsor, Armando Munoz, his cousin, Jacob Villarreal. They're here present today via video to demonstrate their commitment and support for his release. Additionally, Mr. Espinosa will be case managed by myself in our office in the post-conviction unit, Santa Clara County, to help and support him one-on-one with an abundance of housing, employment, and reentry services to help him. Thank you.
Thank you. If you are on the phone and you want to speak in support of Benny Espinosa, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken who wants to speak in support of Benny Espinosa? Chairperson, there appear to be no more speakers in support of Benny Espinosa.
We will now take speakers in opposition to Benny Espinosa.
I'm sorry, we seem to have a couple of hand raised. Ana Jimenez?
Hi, I have
Yes.
a letter that is been written by his wife, Dolores. She's here on Teams, but she's having a difficulty logging in. May I read it for her?
Absolutely.
Okay, thank you. Good morning. My name is Dolores Espinosa. I am Benny Espinosa's wife. I support him, and I have developed a plan to help my husband, Mr. Espinosa. My goal is to create a stable and supportive environment that will minimize the risk of failure and allow my husband to build a positive future within myself and our family. I will be providing a safe and stable home for him. I will ensure he has access to essential resources, including food, clothing, and most important, transportation. I will provide emotional support and understanding. We will continue our necessary counseling and therapy sessions to address any underlying issues and support him going on his ongoing rehabilitation. I will actively support him with creating a resume, interview preparation, and I will help him to reconnect with his positive and supportive family members. I will assist him in fulfilling any parole requirements and ensure he attends all required meetings. While offering support, I will also encourage him to take full responsibility for his actions and choices. We will establish a clear boundaries to ensure a healthy balance. I will provide transportation and to any required appointments until he's fully able to obtain his own transportation. I understand the importance of providing structure and supportive environment for my husband, and I am confident that with this plan in place, he will be able to make a positive contribution to our family and our community. Thank you for your careful consideration of this matter. Sincerely, Ms. Dolores Espinosa. Thank you.
Thank you. And I believe that the hand raised is for opposition. Is that correct, Stephen Dick?
It is.
Okay. So we're able to go. Would you like me to continue with opposition, Chairperson?
Yes, the previous one was of course for support. Now we'll move to opposition. Thank you.
Thank you. Go ahead, Stephen Dick. Your 2 minutes starts when you begin to speak.
The inmate is incarcerated for a gang-related stabbing in which a 15-year-old died. It was a group crime. In 2019, he was involved with a gang-related stabbing. That person survived. It was a group-related crime. Up through 2023, he was engaged in restitution fraud, a violation in PC 155, 484, whatever crime else you want to do. He had his family members put money on other people's books, and then those people would then give the money to him. It was a group-related crime. The decision is sort of interesting. First of all, they don't talk about the restitution fraud at all. It's not even mentioned during the decision. They do indicate that he's been crime-free since 2019, which is obviously not true, but they don't even talk about what happened and those criminal activities that went on. And the other thing that's really weird is that on page 107, the commissioners, and this is page 107 of the transcript, they indicate that they, quote, looked at confidential information, and then the transcript says that was helpful to us, but they don't indicate whether or not they used the confidential information, they rejected the confidential information. There, as far as I know, there's no tape. Maybe there is, I just don't know about it. But it's a little weird thing, especially because a lot of the stuff involving the restitution fraud came from confidential information, as did gang involvement. As in 2024, he was approached by the gang again to do another stabbing, which in this case, to his full credit, he said no and reported it. Obviously led some questions about what exactly happened in 2019. It appears that maybe he didn't leave the gang, that he was actually asked to leave because the person didn't die during the stabbing, and there were some issues about the anger of some of the leadership within the gang, but maybe not. But he did do the right thing in 2024, and that should be absolutely acknowledged and said up front, which we did during the hearing. The problem is that we have violence that is not that old in 2019, and we have continued group
Your 2
criminal
minutes have
activity
elapsed. Please conclude your statement.
in 2023, which is not addressed in the decision, which is also part of the governor's request. Therefore, based on the totality of the circumstances, this is a case that should go back for a decision hearing. Thank you.
Thank you. If you're on the phone and you would like to speak in opposition to Betty Espinoza, and please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Benny Espinoza? Is there anyone else who has not spoken who would like to speak about Betty Espinoza? Chairperson, there appear to be no more speakers for Benny Espinoza.
The next case is Paul Lopez. G as in George, 00079, item number 33. Moderator, please call for speakers in support.
Thank you. If you would like to speak in support of Paul Lopez and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. We have a hand raised for Armando Munoz. Go ahead, Armando, and unmute yourself. Your 2 minutes starts when you begin to speak.
I'm sorry, Commissioner. I was for Benny Espinoza. I was trying to speak earlier. I'm sorry.
I believe you'll have a time after all of the speakers, all the cases are finished. We'll reopen it for other comments.
Thank you.
Not a problem. If you are on the phone and you would like to speak in support of Paul Lopez, please unmute yourself by pressing *6 and identify yourself. Is there anyone who would like to speak in support of Paul Lopez? Chairperson, there appear to be no more speakers in support of Paul Lopez.
We will now take speakers in opposition to Paul Lopez.
Thank you. We do have a speaker card, James Langston, DDA of Stanislaus County. James, if you're with us, go ahead and unmute yourself. Your 2 minutes starts when you begin to speak.
Good morning, Commissioners. James Langston, Deputy District Attorney out of Stanislaus County. And we are asking that this case be referred for a rescission hearing based on the information from the parole hearing and the new information regarding the confidential information received from December 12th of 2024 regarding restitution fraud. And the parole hearing, we learned from the inmate's own words that he continued to engage in gang activity up until 2019. That's 14 years after his initial arrest. And despite all the programming that he has completed, the reviewing psychologist still found that he presented a moderate medium risk for violence, and that could be higher if he is still associating with gang activity. During the hearing, the inmate admitted that he omitted to the psychologist of committing forms of domestic violence. And it should be noted that that interview only occurred, the parole hearing only occurred 2 months and 26 days after that interview, and he still omitted information about past violence. He also admitted committing restitution fraud in 2022 by having family members put money on accounts of other incarcerated people. This behavior, considered in the entirety of the inmate's history, shows a nexus of his past criminal thinking and particularly in gang activity or groups, and his present moderate medium risk for violence. Since the parole hearing, there was a denial of the inmate's request for resentencing under Penal Code Section 1170.95/1172.6, and that was discussed during the parole hearing. We did not have a decision yet, but it has since been denied, and Superior Court Stanislaus Judge Donna Rees ruled that the inmate petitioner failed to state a prima facie case for resentencing. The inmate disagrees that he committed the crime of premeditated.
Your 2 minutes have elapsed. Please conclude your statement.
He does not agree that he committed the crime of premeditated first-degree attempted murder, and he lacks insight and is an unreasonable risk of danger. We ask that he be referred for the rescission hearing.
Thank you. If you would like to speak in opposition to Paul Lopez and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Paul Lopez, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Paul Lopez? Is there anyone who has not spoken who would like to speak about Paul Lopez? Chairperson, there appear to be no more speakers for Paul Lopez.
All right, the next case is Gerardo Resendiz, F as in Frank, 96693, item number 34. Moderator, please call for speakers in support.
Thank you, Chairperson. The first speaker card I have is for Rebecca Rabkin. Rebecca, if you're with us, go ahead and unmute yourself. Your 2 minutes starts when you begin to speak.
Good morning. My name is Rebecca Rabkin, and I'm counsel for Mr. Resendiz. This case comes before the board for review on 2 grounds. One is for consideration for rescission based on what is being called new information from 2005. The other is a referral from the governor on insight grounds. Please refer to the letter that I submitted yesterday for a detailed discussion of the factual issue that is the basis for the rescission consideration. There's a significant amount of evidence available to you on what is ultimately a very narrow factual question, and the evidence weighs in favor of leaving Mr. Resendiz's parole grant undisturbed. Very briefly, the new information is not, in fact, new. It was already incorporated into the POR, but nevertheless, the police reports, along with trial transcripts and the co-defendant's BPH hearing transcripts, all suggest that the panel's question should be answered in the negative. There is not clear evidence that Resendiz did the kicking or stomping. In fact, to the contrary, and thus there's no grounds for rescission, for reconsideration of the parole grant on that front. Turning to the governor's referral, the governor asked the board to determine whether Mr. Resendiz's insight and coping skills are sufficient. The record shows they are more than sufficient. Mr. Resendiz spoke eloquently at the hearing in both English and Spanish about the causative factors of his crime. He provided the board with an extensive set of personal writings that demonstrated self-awareness and understanding and exceptional relapse prevention and parole plans. His CRA was low. Mr. Resendiz completed Road to Freedom, Lighthouse 9, and numerous book reports solely on the subject of sexual offending, as well as programming in domestic violence, substance abuse, sex addiction, alternatives to violence, criminal thinking, gangs, anger management, life skills, and more. He has the support of correctional staff and volunteers at CTF, incarcerated and formerly incarcerated peers, and a vast support network in Mexico that includes reentry professionals and pro-social family and friends. For all the reasons stated here and in my letter, there's no cause to disturb Mr. Resendiz's grant of parole. Please affirm. Thank you very much.
Thank you. The next speaker card I have is for Shelley Eitelson. Shelley, if you're with us, go ahead and unmute yourself. Your 2 minutes starts when you begin to speak.
Thank you. Good morning, commissioners. Thank you for your time and consideration today. My name is Shelley Eitelson, and I am the forensic social worker who had the pleasure of writing the youth offender report for Mr. Resendiz. Mr. Resendiz committed his crime at 16 years old while he was still in the critical stages of cognitive and emotional development. The 3 other people arrested and convicted with him were all adults. As a teenager surrounded by adult co-defendants, Mr. Resendez was especially vulnerable to pressure and negative influence from his older peers. Over the past 20 years of his incarceration, Mr. Resendez has demonstrated significant personal growth and maturation. His prison record reflects his rehabilitation and commitment to change. He has minimal disciplinary history, with his last rule violation more than a decade ago in 2014. He has taken responsibility for his actions and used his time in prison to develop understanding into the factors that led to his offense. When I first met him in April of 2024, I was extremely impressed by his insight, growth, and increased coping skills since his initial hearing in 2019. Though I was tasked with researching and drafting his social history, he had already done a huge amount of work on his own, having written an in-depth biographical statement in which he addressed his own childhood trauma and explained how those experiences shaped his distorted beliefs, insecurities, and control issues that were at the root of his offense. I have spent over 11 hours meeting with Mr. Resendez and interviewed his family members in Mexico. I can attest to his transformation from a juvenile offender who lacked insight and coping skills into a rehabilitated and accountable adult. His considered reflection, remorse, ability to learn from the past and correct his mistakes, plans for the future, and his consistent pro-social behavior over many years perfectly reflect the youth offender's unique capacity for change. For all these reasons, I believe Mr. Resendez does not—
Your 2 minutes have elapsed. Please conclude your statement.
Thank you. I believe Mr. Resendez does not pose an unreasonable safety risk and believe affirming the commissioner's finding of suitability is appropriate today. Thank you very much, commissioners.
Thank you. If you would like to speak in support of Gerardo Resendez and are in video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you are on the phone and would like to speak in support of Gerardo Resendez, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken who wants to speak in support of Gerardo Resendez? Chairperson, there appear to be no more speakers in support of Gerardo Resendez.
We will now take speakers in opposition to Gerardo Resendez.
Thank you, Chairperson. If you would like to speak in opposition to Gerardo Resendez and are on video, please raise your hand using the Microsoft Teams button, and I'll call on you when it is your turn to speak. If you're on the phone and you want to speak in opposition to Gerardo Resendez, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Gerardo Resendez? Is there anyone else who has not spoken who would like to speak about Gerardo Resendez? Chairperson, there appear to be no more speakers for Gerardo Resendez.
The next case is Scott Fialo, AL Adam Lincoln 1830, item 35. Moderator, please call for speakers in support.
Thank you. The first speaker card I have is for Julie Hubbs. Julie, if you're with us, go ahead and unmute yourself. Your 2 minutes starts when you begin to speak. Julie, if you're speaking, we cannot hear you. If you need to unmute by phone, you can press *6. We will circle back to— oh, sorry, go ahead.
Hello, can you hear me?
Yes, we can. Go ahead. We could hear you. You've muted yourself again. I think you'll have to press *6. There you go.
Can you hear me?
Yes, we can.
Okay, thanks. My name is Julie Hubbs. I'm the CEO of About Progress Not Perfection. I met Scott in 2023 at Mule Creek State Prison when he took our Healthy Relationships class. Because we saw something impressive in him, we invited him to keep attending the class, and he did. He attended 5 separate Healthy Relationship classes with us. He seems to understand the impact of his crimes on his victims, their family, and the community. In addition to the workshop, Scott and I worked independently exploring his childhood trauma. As we discovered when he was in foster care at 8 years old, he was a client of Dr. William Ayers, and we processed his molest and rape while he was in the foster care system. He did a phenomenal job. We worked together for about a year exploring his childhood traumas. Upon release from prison, Scott will receive case management, coaching, counseling, and we are excited for the possibility of working with Scott in the community. We hope you continue to find him suitable for release from prison. He's come a long, long way in his growth and development, and there's a lot of good things left inside of him that I'm excited to see him operating successfully in the community. Thank you.
Thank you. The second speaker card I have is for Sean Hawk. Sean, if you're with us, go ahead and unmute yourself or press *6 by telephone. Sean, if you're speaking, we cannot hear you. We'll circle back to Sean at the end. If you would like to speak in support of Scott Fialho and are on video, please raise your hand using the Microsoft Teams button and I'll call on you when it is your turn to speak. If you're on the phone and you would like to speak in support of Scott Fialho, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken who wants to speak in support of Scott Fialho? Chairperson, there appear to be no more speakers.
Can you hear me now?
We'll try one more time. Go ahead.
Can you hear me now?
Yes, we can. Go ahead.
Oh, excellent. Thank you. My name is Sean Hawk, and I appreciate the opportunity to address the board and commissioners today in support of Scott Fialho. Scott was 18 when he committed his life crime, and he was a former gang member. These are parts of the record. He has since renounced his gang membership and association with negative peers. And Scott has admitted that he was impulsive, he was angry, and as Ms. Hubbs just mentioned, some of the reasons for that anger and pent-up impulsivity. In addition to that was the fact that he was 18. We don't condone the choice made, but we do encourage learning from it. Scott's learned and internalized what we teach in our healthy relationships class. He's figured out the source of anger, figured out the source of violence, and he's implemented those tools to prevent him from being violent in the future. And I think that's been shown in his conduct. The embarrassment that Scott spoke about in his meeting with the board is understandable and is rational given the fact that when we grow and adults reflect on the acts of youth, they don't make a lot of sense. The Supreme Court has made clear that youth offenders are not to be viewed as adults or punished as adults. And the controlling legal authority mandates the board give great weight to youth offender factors. The granting panel did just that and weighed his maturity and found that he was suitable for parole. I believe the granting panel were correct in their decision, and I encourage the panel to uphold the grant of parole for Scott Fialho. Thank you.
Thank you. Is there anyone else who has not spoken who would like to speak in support of Scott Fialho? Chairperson, now it appears that there are no more speakers in support of Scott Fialho.
All right, we'll now take speakers in opposition to Scott Fialho.
Thank you, Chairperson. We do have a speaker card for Patrick Graber, DDA. Patrick, if you're with us, go ahead and unmute yourself or press *6 by telephone. Your 2 minutes starts when you begin to speak.
Good morning, Commissioners. Thank you for your time. My name is Patrick Graber. I'm a Deputy District Attorney with Santa Clara County, and I am speaking in opposition to Mr. Fialo's parole release. The people have two primary concerns as it relates to Mr. Fialo. As was brought up in his parole hearing in 2024, there was a troubling incident in his 2023 parole hearing in which Mr. Fialo was dishonest with the parole commissioners and lied about his involvement in a 2015 act of inmate violence against another inmate. When asked about that incident in 2023, Mr. Fialo denied responsibility for the crime and denied causing any of that other inmate's injuries. This was not true, a fact which Mr. Fialo was challenged about during the 2023 hearing. Mr. Fialo had to acknowledge that he had in fact lied to the parole commissioners in 2023 in that hearing and filed a request for a 3-year delay or extension in his parole hearing. Mr. Fialo was again asked about this incident in 2024 and again initially appeared to show dishonesty about that incident. The transcript will show that the first 2 or 3 times Mr. Fialo was asked about that incident, he was again dishonest about it and denied responsibility for the crime, or didn't come forward about his involvement in the crime, only acknowledging his role in it after being asked or pressed on the issue a few times. Mr. Fialo's attorney tried to smooth over this concern by suggesting that Mr. Fialo simply misunderstood the question, but a look at the transcript will show that the question was in fact quite clear, suggesting that Mr. Fialo was still struggling with his ability to be honest with the parole board. This leads to obvious concerns about the defendant's internalization of his programming and his ability to be honest with individuals and with himself about his involvement in criminal activity. The people's other concern about
Your
Mr.
2 minutes have elapsed. Please conclude your statement.
Thank you, Commissioners. I appreciate your time and would ask that the defendant or that the inmate be referred to a rescission hearing.
Thank you. If you would like to speak in opposition to Scott Fialo and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you are on the phone and you want to speak in opposition to Scott Fialo, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Scott Fialo? Is there anyone else who has not spoken who wants to speak about Scott Fialo? Chairperson, there appear to be no more speakers for Scott Fialo.
All right, the next case is Ernesto Gonzalez, H as in Henry 95067, item number 36. Moderator, please call for speakers in support.
If you would like to speak in support of Ernesto Gonzalez and are on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in support of Ernesto Gonzalez, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken who wants to speak in support of Ernesto Gonzalez? Chairperson, there are no more speakers in support of Ernesto Gonzalez.
We will now take speakers in opposition to Ernesto Gonzalez.
The first speaker is John Cross. John, your 2 minutes begin when you begin to speak.
Good morning. We ask that the grant to Ernesto Gonzalez be rescinded and set for rescission hearing. We echo the concerns of the governor. The inmate still has issues with gang activity, substance abuse, and underdeveloped parole plans. The murder that took place August 15, 1992 was heinous and horrible. The inmate and his other gang member co-defendants got into a disagreement with the victim. While the co-defendants were beating and stabbing the victim who was sitting in a car, the inmate came up and shot the victim in the back of the head, execution style, with a .44 caliber handgun, killing him. The inmate's 2018 CRA rated him a high risk for future violence. The inmate's 2023 CRA only came down to a moderate, higher moderate, the second highest rating one can get. He had a placement score of 89. Although it was over a year old at the time of the hearing, the same outstanding issues in the CRA were in the hearing. The inmate continued to minimize his conduct and deflect blame throughout the hearing. As to a separate 1992 stabbing where he stabbed a victim 15 times in a fight, he made it out to be self-defense. In the murder, he made it out to be self-defense, said he perceived the victims as a threat. a man who was sitting in a car being beaten and stabbed and acted instinctively. He has a long history of gang involvement. He said at the hearing he was not a member of a street gang, just associated with them. Said all he did was sell drugs with a street gang, nothing violent. Could not give a good answer why he associated with gangs and negative peers. And he just disassociated in 2021, 3 years ago from the hearing, very recent. As to substance abuse, he could not come up with internal triggers for substance abuse. He could not come up with coping mechanisms to prevent use. His parole plans, he was very overconfident. He said there was nothing that could cause him to break the law and return to prison. The presiding commissioner gave him a hypothetical and he was asked how he would handle it. He said he just could never see himself in that situation and moved on. As such, this improper grant of parole should be rescinded and set for rescission hearing. The inmate is not prepared for grant parole. He has not internalized the
Your 2
program
minutes
that
have
he's
elapsed.
taken.
Please conclude your statement.
Thank you. And he does not have a long period of rehabilitation to distance himself from his prior criminal conduct as the law requires. Submit with that.
If you would like to speak in opposition to Ernesto Gonzalez and are on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in opposition to Ernesto Gonzalez, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken and wants to speak in opposition to Ernesto Gonzalez? Is there anyone else who has not spoken and wants to speak about Ernesto Gonzalez? Chairperson, there are no more speakers for Ernesto Gonzalez.
All right, the next case is Sina Konkanian, AL as in Adam Lincoln 8228, item number 37. Moderator, please call for speakers in support.
Our first speaker is Faraday Konkanian. Your 2 minutes begin when you begin to speak.
Excuse me, do you hear me?
Yes, we can.
Okay, thank you so much. Good morning. I am Sina's mother, Faraday Konkanian, and I want to start by expressing my deepest condolences to the family of Emily Shane Rose for their loss. I can only imagine the immense pain and grief they've endured during the past 15 years. We've seen firsthand the weight of remorse that Sina carries for his actions. He's shown a deep understanding of the pain he's caused, and he's committed to making amends and rebuilding his life in a positive way. During his incarceration, Sina, who is on the autism spectrum, has worked hard to develop the tools and navigate strategies to manage his stressors and problems in his life and the life challenges. We're so proud of his progress he's made, and we believe that he's ready to reintegrate into the society. Sina has participated and learned from many classes, including Gogi, and he has become a Gogi coach. And he's planning, as when he's released, that he can do the Gogi training for others on autism spectrum. And this is a valuable skill to that they can manage the stress and anxiety. This demonstrates his commitment to self-improvement, rehabilitation, and giving back to his community. I firmly believe that Sina is ready to become a productive, law-abiding citizen. I'm sorry for my emotions. We
Your 2
support
minutes
his
have elapsed.
parole.
Please conclude your statement.
Thank you for listening.
Our next speaker is Behruz Konkanian. Behruz, your 2 minutes begin when you begin to speak.
Hi. Yeah, I'm Sina's father. And first of all, I want to say my deepest condolences to the Shane family and the community because of this harsh and immense pain that it caused this event. As we reflect on Sina's past, I want you to consider the remarkable progress he has made over the past 15 years. But it is true that his past action led to his conviction. I want to assure you that the person he was is not the person he is today. Today, Sina is a man of faith, kindness, and compassion. He is confident, self-aware, and deeply committed to being a positive contributor to society. This transformation has been witnessed firsthand by his family, doctors, prison staff, friends, and fellow inmates. Despite the prison, Sina has consistently demonstrated his ability to remain calm, reflective, and committed to personal growth. As you know, prison is a very harsh place, and Sina not even once showed being out of control or doing something illegal. From the level 4 security, he came to level 1 in a couple of years, and he finished many courses, including GOGI classes that he took it by himself, and many of the classes
2 minutes
in
have elapsed.
universities.
Please conclude your statement.
Yeah. And then just we want to, we are confident that he can be the same nice person as it is now in prison while he's out with the family. Thank you.
We have a hand raised for GOGI Coach Taylor. Your 2 minutes begin when you begin to speak.
I'm so very proud of Coach Sina. There are 24,000 CDCR students that we have on our roster. Of that, 160 have gone through the 2-year program and have become coaches. Of those, 60 have been released, and only 1 has recidivated due to an addiction issue. I've submitted a written statement of my support. I just want to say how proud I am of Sina, because he was the very first of our coaches to complete certification as a facilitator of groups, GOGI groups. He does have employment waiting for him. He will be facilitating GOGI groups for individuals on the autism spectrum. I have more confidence in him than any one of our other 24,000 students. And please read my written statement, and we will welcome him home with very open arms.
If you'd like to speak in support of Sina Kankanian and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you're on the phone and want to speak in support of Sina Kankanian, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken and wants to speak in support of Sina Kankanian? Chairperson, there are no more speakers in support of Sina Kankanian.
All right, we'll now take speakers in opposition to Sina Kankanian.
We have a number of speakers for opposition. Our first speaker is Jerry Churchill. Jerry, your 2 minutes begin when you begin to speak.
I'm Jerry Churchill. Emily Shane was a beautiful 13-year-old girl. She lived down the street from us, and she was in my son's class. My 2 oldest sons had just attended her bat mitzvah shortly before Sina Kankanian took her life. She was funny and sweet and creative and full of energy. She was certainly going to make a beautiful difference in the world. She had her whole life ahead of her. And my oldest son is the same age as Emily. He just turned 29 2 days ago. That's the age Emily should be right now, had Sina Kankanian not stolen her life from her. On April 3rd, 2010, when she was 13, Emily's life was senselessly taken away by this psychopath, Sina Kankanian. And before you judge me on the use of my word psychopath, or think this was just an unfortunate accident, please consider that one of the firefighters who responded to the scene the day she was killed told me personally, and I do believe he testified at trial, that when he informed Mr. Kankanian that he had killed a young girl, Mr. Kankanian responded, "Fuck that bitch, I hope she's dead." This is the definition of psychopath. someone with no conscience. I attended both trials and never once saw Mr. Konkanian and expressed remorse for killing beautiful Emily. I heard many witnesses testify that they called 911 that day, saying, "This guy is driving crazy. He's going to kill someone." This was not an accident. Mr. Konkanian knew that his actions behind the wheel that day were dangerous and would likely result in someone's injury or death, which it did. It resulted in the death of beautiful Emily Shane. Please deny parole to Sina Konkanian. His open demonstration of a lack of conscience demonstrates that he is a danger to society. Do not allow him to walk free, because Emily never will. And a scene I can never get out of my mind.
Your 2 minutes have elapsed. Please conclude your statement.
Emily's funeral, her parents and her grandparents who had to shovel dirt onto her casket, into her grave. No grandparent or parent should ever have to bury a child. Please deny parole to Sina Konkanian. He's a monster.
Our next speaker is Winston Churchill. Winston, your 2 minutes begin when you begin to speak.
My name's Winston, and I was friends with Emily Shane. She lived down the road from me. We both went to Malibu Middle School. She was 1 grade ahead of me. She was kind and friendly and very well liked by all of our friends at our school. Not long before she was killed, my brother and I attended her bat mitzvah. We had a lot of fun. She was very, very happy. Her life was just starting out. She was killed on April 3rd, 2010, when she was 13. I was 12, and I remember that being my first experience with death. I attended her funeral, and I remember how devastated her family was, especially her parents, Ellen and Michelle. When her killer, Sina Konkanian, went to trial for her death, I attended one of those days of the trial. One thing that was seared into my brain from 12 years old, one of the first responders was on the stand as a witness. I remember he testified about the events and telling Sina Konkanian that he killed a young girl with his car. He said that Sina Konkanian said something to the effect of, "Fuck that bitch, I hope she's dead." As I mentioned, I was 12 years old when this happened. It was the first time I ever experienced what true evil looked like. He wasn't remorseful. This wasn't an accident. There were many, many 911 calls just before Emily's death saying that he was driving crazy and that he was going to kill someone. He knew that his actions that day, driving recklessly, were likely to result in the injury or death of another person, and it did. That person was my friend Emily. Please deny parole to Sina Konkanian. He robbed Emily of her life. He does not deserve to walk free. Thank you.
Our next speaker is Michael Shane. Michael, your 2 minutes begin when you begin to speak.
Commissioners, I'm before you not just as a grieving father, but as Emily's voice, the voice she lost forever at 13 when this man deliberately ended her life. For 14 years, I've awakened every morning to crushing reality that she's gone while he awaits freedom. The previous panel made a devastating error by ignoring crucial evidence. His chilling words at the crime scene still haunt me. F you, the bitch deserved to die. How can anyone make sense of these words alongside his claimed remorse? Yet the panel never confronted this glaring contradiction. I've watched his calculated manipulation of the system, feigning severe autism during the trial, then conveniently recovering enough to participate in prison programs, yet no college degree. The panel accepted his performance in a controlled setting while dismissing his history of deception and premeditated nature of his crime. Emily never got a chance to attend high school, fall in love, chase her dreams. But the previous panel seemingly forgot her, a bright, loving child whose future was stolen. When they weighed his practiced words against his brutal actions, his convenient religious conversion before parole consideration was accepted without scrutiny of this authenticity. Our community members spoke here today. I heard and feared disbelief at this decision. How can we explain to other children that the man who coldly murdered one of their peers might walk free? With my heart still shattered, I implore you to revoke this unwarranted grant. This isn't about vengeance. It's about protecting other family from existing the nightmare we live in every day. The panel's failure to address these critical inconsistencies isn't just procedural, it's a betrayal of justice for Emily and a danger to every child in our community. Thank you. Deny it.
Our next speaker is Emily Shane. Emily, you have 2 minutes. Your 2 minutes begin when you begin to speak. I'm sorry?
Ellen Shane. Emily's dead.
Can you hear me?
Yes, we can.
Okay, thank you. I am Emily Rose Shane's mother. How do I convey the utter anguish, suffering, and pain AL-228 has caused me, our family, friends, and community? It will forever weigh on my heart and being. It is a life sentence. How do you measure a child's life? How do you justify releasing a remorseless murderer? Is it because he served his bare minimum of his sentence of 15 to life? Because he was coached to present well at hearings? Or maybe because he's adept at acting, he used those same skills that he misrepresented himself during both pretrial hearings and court proceedings? Or perhaps it's his newfound religious conviction or claims that meditation and deep breathing now control his tendency to rage. For 15 years, he has lived in a structured medical facility, monitored to take his medication, his behavior observed. If released, there's no such structure, no guarantee he will remain medicated. He murdered Emily when he was off his meds. His family, by his own admission, are accustomed to using alcohol. So what happens when he's in this environment or provoked in some way to cause anger? Emily was 13, joyful, bright, full of promise. She is dead because of him. And as everyone has repeated here before, his response upon learning he killed her was, "I don't give a F." 15 years isn't nearly enough for justice for our daughter's life. And I do seek justice, not vengeance. He must serve more time to prove true remorse, work on his mental health rehabilitation, grasp the full consequences of his actions, and ensure he never harms
Your
another
2 minutes have
innocent
elapsed.
person.
Please conclude your statement.
I will. I have one quick sentence. Emily had no second chance. Please keep her killer behind bars. He is a risk to society. Prevent another innocent life from being lost.
Our next speaker is Marna Miller. Marna, your 2 minutes begin when you begin to speak. Marna Miller, if you're speaking, we cannot hear you.
Hello, can you hear me?
Yes, we can.
Hi, I am the retired deputy district attorney on this case. And what I will say is that the defendant was enabled by his family. His family knew he had anger management issues, and they still bought him a souped up automobile, which was the murder weapon. In this case, they excused all of his actions. And while I understand that they are saying that they are remorseful now, I didn't hear that during the trial. Putting that aside, these are the people that the defendant is going to go home and live with. I believe that this defendant had anger management issues. He showed the anger management issues. And while you can say that he is able to comport his behavior now, that behavior is being able to be controlled because he is in a controlled environment. Given the opportunity to live in a society under the control of these people who weren't able to control him before, is not a safe care for the community. I believe that he also was extremely manipulative during the trial, acted completely like an imbecile, drooling at the counsel table, but then when he was in the back, he would call his girlfriend, who was up on the witness stand, he would call her and tell her she looked hot. She was doing a great job during the trial. So I believe that he is manipulative, and I believe that he has manipulated the commission, and for public safety reasons, he should not be allowed to be paroled at this time. Thank you.
Our next speaker is Susan Schwartz. Susan, your 2 minutes begin when you begin to speak.
Thank you. I am a former deputy district attorney. At the trial of this matter, Mr. Konkanian submitted a report by psychologist Mary Large in support of his defense. Dr. Large, after an extensive analysis of Mr. Konkanian's lifelong behavior, found that behavior to be replete with examples of problems with disinhibition as manifest in reports of emotional outbursts or tantrums well into adulthood, property destruction, and provocative comments directed towards authority figures such as airport security officers and highway patrol officers, and noted Mr. Konkanian had 2 involuntary hospitalizations during his early 20s due to tantruming to such an extent that his parents were concerned about their own safety. And she concluded that Mr. Konkanian, in an uncontrolled setting, has a fundamental inability to adequately self-regulate or to exert voluntary control over his behavior. Granted, he has controlled his behavior in a closely supervised setting. However, he is going to be released back to the same family that could not control his behavior in his past and that excused or enabled his drinking and his substance abuse. We are very concerned that Mr. Konkanian will and does remain a risk to the public in an uncontrolled setting, and we are very concerned that
your 2 minutes have elapsed. Please conclude your statement.
Behavior he evidenced when he killed Emily Shane may be repeated.
Our next speaker is Flechelle Morin. Flechelle, your 2 minutes begin when you begin to speak. Flechelle Morin, are you with us?
Yes, can you hear me?
Yes, we can.
Members of the Parole Board, thank you for the opportunity to speak today. I stand before you to strongly oppose the parole of AL 8228, a man whose violent actions deliberately took the life of Emily Shane, an innocent 13-year-old girl. This man intentionally used his vehicle as a deadly weapon, not through accident or negligence, but through calculated anger and brutality. His vicious act permanently robbed the family of their child, their peace, and their future. When considering parole, the foremost priority must be public safety. Allowing a man capable of such intentional and violent rage back into society poses a clear and unacceptable risk to our community. Someone who deliberately targets and kills a child out of anger demonstrates a profound and lasting capacity for violence and disregard for human life. If this individual were released today, can we confidently say that he will never again allow his anger to overpower his judgment? The brutal nature of his crime indicates a deep-seated aggression that could easily resurface, placing more innocent lives at risk. The safety and well-being of our families, friends, and community must come first. For the sake of the victim's memory and the protection of every innocent citizen, I urge this board to deny parole to AL 8228. Justice demands accountability, and public safety requires continued incarceration. We cannot afford to gamble with human life. Thank you.
Our next speaker is David Ralston. David, your 2 minutes begin when you begin to speak.
Thank you. Today is March 19th, 2025. Sienna Concannon killed Emily Shane on April 3rd, 2010, when he used his vehicle to run her over as she walked along the side Pacific Coast Highway. The case took several years to come to trial, and in 2012, he was convicted and received the sentence of 15 years to life. So I find it hard to understand how it is that a man who brutally and senselessly ended the life of an innocent 13-year-old girl would already have been paroled in 2023 if the governor hadn't reversed that decision. And in that report at the time, I quote, they stated, given the close nexus of his mental health stability and his risk for future violence against himself and others, I've determined that Mr. Concannon must demonstrate a longer period of sustained medication compliance, improved self-awareness, and increased self-reliance before he can be released safely. That report was issued on October 18th of 2023. What is the rush to release this person? As you once again consider paroling a man who was not even served 15 years of the 15 years to life sentence he received after pleading innocence, it seems to me that the entire reason we are commenting on this matter is being overlooked. On April 3rd, 2010, again, not even 15 years since this death occurred, through his actions and decisions that day, he sentenced the Shane family to live out the rest of their lives in a state of grief and loss that no person can truly understand who has not experienced the loss of their child. He was 27 when he killed Emily. He had a job. He was in a relationship with a coworker that he lived with. He had a car. He had a family and friends. By every measure, he is what we consider an ordinary adult man. He had agency in his life, and when he lost his job, that small amount of adversity was, according to him, a reason for him to get in his car and engage in a 20-mile vehicular rampage that only ended.
Your 2 minutes have elapsed. Please conclude your statement.
Thank you. This was the act of a deeply selfish and self-involved person who has no interest in the life or safety of others. It is the act of someone who is either incapable of the most basic amount of empathy and regard for his fellow citizens, or someone who looks at the lives and safety of strangers as inconsequential and of no value in comparison to his own emotional state. I would urge you to understand that the Shanes see him in a way that perhaps you are not able to, and with a degree of clarity you are not.
Thank you so much for your comments.
Please don't.
Our next speaker is Halen Conrad. Halen, your 2 minutes begin when you begin to speak. Halen Conrad, are you with us? Halen Conrad, or if you're speaking, we cannot hear you. We will circle back. Our next speaker is Elvis Diaz. Elvis, your 2 minutes begin when you begin to speak.
Thank you. I'm a friend of the Shane family, whose beloved 13-year-old daughter, Emily, was tragically killed by Mr. Concannon in 2010, and he now seeks parole. However, he possesses a substantial risk to public safety. At the time of the incident, he was not taking his prescribed medication, and there is no assurance he would remain compliant if released. His pattern of uncontrolled anger renders him a potential threat. I mean, even Governor Newsom recognized this danger when he overturned Mr. Concannon's prior parole, citing inconsistent treatment compliance. If his mental health deteriorates or his anger resurfaces, the likelihood of another tragedy cannot be discounted. Mr. Concannon has not demonstrated genuine remorse for causing Emily's death. At trial, he showed indifference upon learning that he had taken a life, and his more recent statements have been largely scripted rather than heartfelt. His absence of authentic contrition strongly suggests he has not fully rehabilitated or accepted responsibility for his actions. Emily was a bright and loving 13-year-old, simply walking to meet her father after sleepover when she was struck and killed. The Shane family, as well as our broader community, has been permanently affected by this devastating loss. Their ongoing grief stands in stark contrast to Mr. Konkanian's lack of empathy. Parole is intended for individuals who have demonstrated meaningful rehabilitation and no longer pose a threat to society. Ultimately, parole is a privilege contingent on inmate proving they no longer present a danger. Governor Newsom's 2023 reversal decision underscores this reality. When considered as a whole, I find the evidence shows that Konkanian currently poses an unreasonable danger to society if released. Therefore, I reverse the decision to parole Mr. Konkanian. In light of Mr. Konkanian's history of anger
Your 2 minutes have
management,
elapsed. Please conclude your statement.
questionable remorse, and the inability to ensure he would remain medicated once free, the reversal of his parole grant is not only justified,
All right,
but
thank you, sir. All right,
tragedy.
I understand this case. Please hold your comments to 2 minutes, and if you're given a warning by the moderator, you may then give us a final sentence on your recommendation to this panel meeting on Bonk today. Thank you for understanding.
Our next speaker is Rochelle Huppin. Rochelle, your 2 minutes begin when you begin to speak.
Hi, can you hear me?
Yes, we can.
Okay, great. I believe I was the last person to see Emily alive. I saw the inmate's car driving right behind me, he intentionally turned to hit her on the road on Malibu. There are 2 lanes, the lane closest to where she was walking, I was in the lane next to it. He came behind me and went and hit her. And as I said, at both trials, she looked like a rag doll going up in the air. It was horrifying. His car was airborne and hit the wooden pole, turned upside down. Unfortunately, help came a few minutes too late, but he would not get out of the car for them. He was belligerent. People spoke about his swearing. It was way more than that. And she was knocked out of one of her shoes. She had a tennis shoe sitting on the ground. 15 years later, every time I see a single tennis shoe, I am brought back to that day. It's absolutely horrifying. I have some empathy for his family, but they lost him that day, but they lost him a long time sooner than that. I have a daughter who, Emily should be her age right now, but she's been gone. My daughter is a psychiatrist now, worked at LA County in that same population. I don't have a lot of hope based on what I've heard from her about his ability to come back to society. What I don't understand is if he had killed somebody who was in their 80s, maybe, just maybe, he would have served some of his time, although he'd still be a threat, so it's irrelevant. But she lost an entire lifetime. That is what 15 years to life means. And in the case where you kill somebody very young, you should
Your
be
2 minutes have elapsed. Please
Yeah.
conclude your statement.
I have nothing more to say. I think everyone has really spoken clearly that he should not be released. Thank you.
Our next speaker is Julianne Walker. Julianne, your 2 minutes begin when you begin to speak.
Good morning again. In this matter, medicine compliance is the high risk factor. Yet despite the clear evidence in the records that the inmate refused to take his meds, the CRA clinician, neither the CRA clinician nor the panel investigated those entries in his records by asking for an investigation, speaking to his team, and instead took the word of the inmate who lied to everyone for 5 years about taking his medicine, and he was off his meds at the time of the murder of Emily Rose Shane. Why didn't the clinician ask? Look at the med records to see why the inmate wanted to titrate down his med dose in 2018 and why he went back up in 2023. He said that was unclear and didn't go further into it. Instead, the inmate gave the panel inconsistent reasons that the treatment team was changing his meds due to cost, and then on the other hand, that he felt he was better and didn't like the side effects. This is precisely the risk. And how do we prevent this in the future? When you look at his relapse plan, as the governor notes, he still primarily relies on the support network and not himself. He is going back to his family that enabled him in the past, who will provide housing rather than him getting a job and supporting himself. Why not finish his college degree so he can better support himself? This is directly related to the risk factor of stress and coping in the caveat the CRA clinician noted in his report and his rating. Why was he being a coach rather than working on his own needs, such as completing his college degree so he's better assured of having a job on the outside? With respect to the rating being low, there were so many risk factors with moderate relevance. The 4 historic risk factors: past problems with relationships, employment, major mental disorders, and treatment response, a key. 2 clinical current risk factors.
Your 2 minutes have
again,
elapsed. Please conclude your statement.
Moderate relevance, thank you, and 2 risk management factors, stress and coping and treatment response being the most. This evidence, along with much more, indicates there's good cause to set a rescission hearing to determine.
Thank you, ma'am. We've got that. Good. Thank you for your recommendation to the board.
At this time, we'll circle back. Halen Conrad. Halen, if you were with us, your 2 minutes begin when you begin to speak. Halen Conrad. If you'd like to speak in opposition to Sina Kankanian and are on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in opposition to Sina Kankanian, please unmute yourself by pressing *6 and identify yourself.
Gail Pergamet.
We have a speaker in opposition.
Yes.
Yes.
My name is Gail. My name is Gail. Emily was my cousin. I request that you deny parole for Sina Kankanian. His excuse for murdering Emily was he was, quote, having, excuse me, having a bad day. His level of bad day involving work and his girlfriend, nothing spectacular compared to the day-to-day problems that everybody faces. He attempted, while driving up Pacific Coast Highway multiple times, to target other vehicles. And what he chose to do was to crush a child as she stood by the roadside waiting for the light to change. The first responders who extracted him from his car said he asked, quote, "Is the bitch dead?" What was he doing? He was doing revenge. Revenge on the world because things were going badly in his personal life. I fully appreciate that his mother and father who spoke today are people of feeling, that they experience grief, that they experience remorse about this entire state of affairs. But unfortunately for them, they had the bad luck to have Sina as a son. There has been nothing remotely parallel to what we heard from them today in terms of emotion, remorse, and response coming from Sina. He has expressed none of this to Emily's parents, to my family, to the community. Yeah, he's doing a great job.
Your 2 minutes have elapsed. Please conclude your statement.
Okay. He poses an ongoing threat to the rest of the world if you, the board, should choose to release him. Please take this risk extremely seriously. Asperger's people with whom I work with on a daily basis.
Thank you, ma'am. Thank you, ma'am. Thank you for your recommendation.
Yeah. Okay.
See, we have a hand raised for Jerry Churchill.
Yes, I would like permission to read the statement by my son, Kearns Churchill, who did submit his statement in advance to the parole board, but due to his work schedule, he was not able to read it and asked me to read it on his behalf, please.
Go ahead.
My name is Kearns Churchill, and Emily Shane was my friend, neighbor, and classmate. She lived just down the road from my family, and we were in the same class at Malibu High School. The thing I remember most about Emily was how fun-loving and well-liked she was by all our friends at school. Shortly before she was killed, my brother and I attended her bat mitzvah. I remember how happy she was that night and how much fun we all had together. She really had her whole life in front of her. I remember very clearly finding out that she had been killed. It was the day before Easter Sunday in 2010. We were in the 8th grade. She was 13 and I had just turned 14. It was the first time I knew someone who had been killed. It just never occurred to me that someone our age could die. I remember going to her funeral and seeing how sad her family and friends were. One thing I will never forget is going to school the next day and going to class and seeing her desk empty and realizing that she wasn't there and she was never coming back. She was never going to be there. I remember our 8th grade graduation about a month after she was killed and realized she wasn't there and wouldn't be going to high school as we were all so excited to do. She was robbed of that experience and so many of the experiences all of her friends have been able to enjoy. She was robbed of that by Sina Konkanian. I am still friends with many of our Malibu middle school friends. We still hang out and see each other often. Emily should be here. Emily's life was senselessly taken by Sina Konkanian, whose reckless, dangerous, irresponsible driving on April 3rd, 2010 caused her death. Please deny parole to Sina Konkanian, as he has no right to walk free after robbing Emily of her life.
Is there anyone who has not spoken and wants to speak in opposition to Sina Konkanian? Is there anyone else who has not spoken and wants to speak about Sina Konkanian? Chairperson, there are no more speakers for Sina Konkanian.
All right, the next case is Michael Pinella, T as in Tom 02350. Everybody wants to take a break, I'm hearing. Okay, we'll take a short 5-minute break then. The time now is 10:16. We'll do our best, 10:46. We'll do our best to return at 10:51, please.
I'm on 5 minutes.
If you wish to speak, please complete a fillable speaker card and send to bph.speakercards@cdcr.ca.gov. The speaker card is available on the board's website at cdcr.ca.gov/BPH. Completing the form is voluntary. All persons may attend the meeting and make comments. If you wish to remain anonymous, enter anonymous next to the speaker name on the speaker card. You may also enter the last 2 digits of your call-in number for identification when it is time for you to speak. You may also call 916-322-4752 to register your speaker information. If you need to leave a voicemail message, please include your name or anonymous, your telephone number or last 2 digits, organization if applicable, name of case on agenda and CDCR number, whether you are calling in support or in opposition of parole, and identify yourself as family, attorney, district attorney, victim, next of kin, anonymous, or other. Si desea hacer un comentario, por favor llene una tarjeta y lo manda al correo electrónico bph.spercards@cdcr.ca.gov. La tarjeta está disponible en nuestro sitio web al cdcr.ca.gov/BPH. Llenar la tarjeta es voluntario, quien quiera puede asistir y hacer comentarios. Si quiere mantenerse anónimo, ponga anónimo en vez de su nombre o ponga los últimos 2 números de su número telefónico. También puede llamar al 916-322-4752 y dejar la siguiente información: su nombre o diga anónimo, su número de teléfono o los últimos 2 números, su organización, el nombre y el número del caso, si está de acuerdo con o en contra del caso, su relación al caso, si es pariente, abogado, fiscal o víctima. If you wish to speak, please complete a fillable speaker card and send to bph.speakercards@cdcr.ca.gov. The speaker card is available on the board's website at cdcr.ca.gov/BPH. Completing the form is voluntary. All persons may attend the meeting and make comments. If you wish to remain anonymous, enter anonymous next to the speaker name on the speaker card. You may also enter the last 2 digits of your call-in number for identification when it is time for you to speak. You may also call 916-322-4752 to register your speaker information. If you need to leave a voicemail message, please include your name or anonymous, your telephone number or
All right, moderator, it appears we are all back. We ready to go?
Yes, sir.
All right. The next case is Michael Pinella, T-Tom 02350, item 38. For this case, Commissioner Purcell has stepped out, and so she will not be involved in public comment, nor deliberations, nor voting on this case. However, Commissioner Chappelle has stepped in, and he should be joining us remotely. I see him there. Commissioner Chappelle, are you present, sir?
Good morning. Yes, I'm here.
All right, perfect. Thank you so much. All right, then we will begin with speakers in support of Mr. Pinella.
We have a number of speakers for this case. Our first speaker is Casey Brown. Casey, your 2 minutes begin when you begin to speak. Casey Brown, if you're speaking, we cannot hear you.
All right, my name is Keith. I have the wonderful pleasure of being coached and guided by Mr. Pinella. He is the kind of person that is quite selfless in helping others in recovery. I am where I am now as a substance use counselor in California, working at a homeless shelter in California. On my way to start my master's program here in California, in large part due to the work that Mr. Pinella put in with me. I am offering in support of Mr. Pinella basically whatever he needs. He's the kind of person that I really feel would be a great attribute to this community. And my support looks like standing in when he's in crisis, giving him space for someone to talk to, a familiar face, which is one of the hardest parts of transitioning out. I am a relapse prevention counselor here at my job. I work with people daily in this, and will continue to support Mike Pinella in this. I would also like to say that my experience with him is in times of hardship. He's the kind of person that people were flocking to for guidance, and I deeply, deeply respect what he was able to do in those spaces, and I really do foresee him continuing that kind of work upon his release.
Our next speaker is Patricia Pinella. Patricia, your 2 minutes begin when you begin to speak. Patricia Pinella, are you with us?
I am. Good morning. I'm speaking in support of my older brother, Michael Pinella. I have been visiting my brother regularly and frequently for his 25-year incarceration. I have seen significant changes over this time. In the beginning, he was stuck, simply serving time and staying stagnant. Then he started realizing change was possible even while in custody, and chose to spend a majority of his sentence becoming a better man. We have spent hundreds of hours in visiting and on phone calls, processing childhood, learning to take responsibility for our adulthood, and helping each other walk through life's challenges. He is very knowledgeable in mental health and uses his CBT triangle training of thoughts, feelings, and behaviors, as well as new coping skills. He has facilitated groups mentoring fellow inmates. This has been confirmed during visiting, as other inmates or other families will approach my brother to thank him for his help. Michael has attainable parole plans with life goals after prison. He is eager to work at his guaranteed job immediately after parole. CDC has provided vocational training in welding, CNC machine, and construction, which will offer more career choices for him. His instructors have been instrumental in learning these skills as well as interpersonal relationships. My parents are gifting him a truck which will allow him to be independent in living, working, school, and a 12-step program. Michael has been clean and sober for 17 years now and will continue. Our friend Shane Lehman will be his interim sponsor, helping him get connected to a home group in the AA or NA community. Several successful parolees have kept in touch with Michael, who will help him navigate the life after parole. Michael's transitional housing is only 12 minutes from my home. I believe he will be safe, welcome, and comfortable since we have lived in this area most of our lives. I look forward to continuing our relationship
Your
with
2
life
minutes have
talks
elapsed. Please conclude your statement.
soon taking place on the beach or local hills. Please affirm the decision. Thank you.
The next speaker is Charles Larson. Charles, your 2 minutes begin when you begin to speak.
Can you hear me now?
Yes, we can.
Thank you. I am Michael's stepfather, who met Michael 6 years ago. Michael immediately told me about the crime he committed and was able to explain what led him to do this and what he has done to understand and mitigate those things. Michael has shown to me a deep remorse for his behavior and expressed it in the many apology letters and victim impact statements and papers he has shared with us. His understanding of his causative factors run deep. We have read his papers of criminal thinking, drug abuse, domestic violence, child abuse, violence and rage, relationships, and mental health. Each time he shows he has gained insights, often through teaching the classes to others. He receives great satisfaction in helping others and sees how that helps himself as well. Michael knows that his sobriety is the crux of his continued recovery, and he delves into that in his extensive writing on his parole plans. He has over 10 detailed plans starting from day one. As accountability partners, Michael's mother and I are very pleased with the program and network Michael has for himself, including the transitional housing, parole officers, and sponsors for the local NA and AA 12-step programs. I believe that the governor's office is correct in understanding the importance of Michael's continued sobriety, but I also believe in the opinion of Dr. Spain in Michael's low-risk psych evaluation, and I quote, "If Mr. Piniella were to be released right now with his existing plans, they would be adequate to manage his risk in the community," end of quote. Michael's mother and I, his brothers and sisters, their families, his 12-step sponsors, the ex-prisoners he has helped along the way, who are now successfully out showing him the way, the transitional housing self-help programs, the parole officers.
Your 2 minutes have elapsed. Please conclude your statement.
With Michael having a truck, job, tools, bank account, and housing with us, we
Sir,
believe
sir,
that
your final recommendation, please.
we hope you'll allow him to become a productive member of society. Thank you.
Thank you.
Next speaker is Joseph Magazzani.
Good morning. My name is Joseph Magazzani. I had the privilege of representing Mr. Piniella at his most recent parole suitability hearing. The governor raises really two concerns in terms of asking this full board to review Mr. Piniella's grant of parole. One is whether he has adequate relapse prevention plans, and one is whether he has adequate social supports. What I would ask the panel to do is, to review the plans he submitted on page 459 of the master. They are incredibly detailed, incredibly personalized. They cover all of his risk factors. I've been doing this a while. I don't know that I've seen much better relapse prevention plans than what Mr. Piniella put together. I will point out that even as early as the 221 CRA, the clinician felt that he had presented a solid plan to prevent relapse, ultimately finding him to be a low risk for violent relapse. He's denied in 2023. He gets a new CRA. The clinician in that CRA thought his parole plans were viable, thought they mitigated his risk to the point of being a low risk of recidivism. The panel in 2024 again discussed his plans with him, again reviewed his plans, specifically stated that they thought his plans were sufficient, that they thought he had a sufficient understanding of his triggers and sufficient coping skills in place to prevent relapse. In terms of social supports, I asked the panel to consider the speakers that are speaking on his behalf today, the numerous support letters submitted on his behalf, and the community resources he's identified in the parole plans he submitted to the master packet on page 517. He identifies numerous reentry resources that he can refer to if any of his other social supports fall short. In short, the governor does not identify any specific issue with his relapse prevention plans and parole plans. No one else who's reviewed this matter has found them. Therefore, I think they do sufficiently mitigate his risk, as all these people have concluded. I ask the full board to reach the same conclusion today and uphold the grant of parole. Thank you.
If you would like to speak in support of Michael Piniella and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you're on the phone and want to speak in support of Michael Piniella, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken who wants to speak in support of Michael Piniella? Chairperson, there are no more speakers in support of Michael Piniella.
We will now take speakers in opposition to Michael Piniella.
First speaker is Gina Pearl. Gina, your 2 minutes begin when you begin to speak.
Thank you. In November of 1999, Michael Piniella violently murdered 20-month-old Jonathan Bell by forcefully punching the little boy multiple times in the abdomen. Jonathan suffered more than 50 bruises to his abdomen and multiple internal injuries, which caused a very slow and painful death for this infant. In the months leading up to his trial, Michael Piniella made comments to multiple people, including, "I killed the little bastard, and I'm going to get away with it just like O.J. Simpson did." He even threatened to kill one of the witnesses who would eventually testify against him. In October of 2000, a jury found Michael Piniella guilty of first-degree torturous murder of Jonathan Bell. If convicted of this crime today, the sentence would be life without the possibility of parole. When he entered CDCR, he picked up multiple rules violations beginning in 2006 and stemming through 2011. Additionally, starting in 2007, at the same time he claims to have become clean and sober, he began a manipulative and calculated scheme to avoid restitution payments to Jonathan Bell's family. For 8 years, every single day, while completely sober, inmate Piniella manipulated his mother, the same mother he plans to live with if released, into believing his story and working with other inmates to put money on their books rather than his, so CDCR could not automatically deduct payments based on his legal obligations to Jonathan Bell's family. At his first parole hearing in 2001, he was granted parole, a decision which was quickly reversed by Governor Newsom. Governor Newsom found significant negative factors demonstrating unsuitability, including the relatively recent 8-year restitution fraud demonstrating a significant gap in insight.
Your 2 minutes have elapsed. Please conclude your statement.
Thank you. We're asking the board to rescind the grant of parole. Thank you.
We have a hand raised for Shannon Stark. Shannon, your 2 minutes begin when you begin to speak. Shannon, if you're speaking, we cannot hear you. It looks like you're muted. Shannon, are you there? If you would like to speak in opposition to Michael Piniella and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. If you're on the phone and want to speak in opposition to Michael Piniella, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken and wants to speak in opposition to Michael Piniella? Is there anyone else who has not spoken and wants to speak about Michael Piniella? Chairperson, there are no more speakers for Michael Piniella.
All right, we will just pause for a few moments while we bring Commissioner Purcell back into the room, and we'll excuse Commissioner Chappelle, and we'll resume with him when this matter comes in our private meeting.
Thank you.
All right, the next case is Dennis Rock, V as in Victor 72383, item number 39. Moderator, please call for speakers in support.
If you would like to speak in support of Dennis Rock and are on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. Krista Stahl, you have 2 minutes. Your 2 minutes begin when you begin to speak.
Can you hear me?
Yes, we can.
Okay, thank you. Good morning, commissioners, and thank you for giving me the opportunity to speak on behalf of my brother. Um, I just want to say that throughout the past many years, I have seen my brother work very hard to take the classes and counseling necessary to rehabilitate. And I've seen his deep sadness and sorrow for the crime he has committed. I've also watched him work very hard with the dogs and the joy and pride that he feels when he has trained a dog that is going to a veteran or a young girl that needs a service animal, and the positivity that he knows he's bringing into the world. And I just ask that you will give him the opportunity to take that positivity and goodness into the community, because I believe that that's exactly what my brother will do, is he will work hard as he has for many years. He will work hard to be a light. And his remorse for his crime is something that I feel like he's been working very hard to redeem himself from. So I just ask that you please affirm his parole and grant him the ability to be a light in the world. Thank you.
If you are on the phone and want to speak in support of Dennis Rock, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who has not spoken who wants to speak in support of Dennis Rock? Chairperson, there are no more speakers for Dennis Rock. I'm sorry, there are no more speakers in support of Dennis Rock.
All right, we'll now take speakers in opposition to Dennis Rock.
If you would like to speak in opposition to Dennis Rock and are on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in opposition to Dennis Rock, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Dennis Rock? Is there anyone else who has not spoken who wants to speak about Dennis Rock? Chairperson, there are no more speakers for Dennis Rock.
All right, the next case is Eugene Strickland, P as in Paul, 56847, item number 40. Moderator, please call for speakers in support.
If you would like to speak in support of Eugene Strickland and are on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in support of Eugene Strickland, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in support of Eugene Strickland? Chairperson, there are no more speakers in support of Eugene Strickland.
We will now take speakers in opposition to Eugene Strickland.
If you'd like to speak in opposition to Eugene Strickland or on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in opposition to Eugene Strickland, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in opposition to Eugene Strickland? Is there anyone who has not spoken who wants to speak about Eugene Strickland? Chairperson, there are no more speakers for Eugene Strickland.
All right, the last case today is Zhu Tao, AX Adam X-ray 0705, item number 41. Moderator, please call for speakers in support.
If you'd like to speak in support of Zhu Tao and are on video, raise your hand using the Microsoft Teams button and I will call on you when it's your turn to speak. If you're on the phone and want to speak in support of Zhu Tao, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken who wants to speak in support of Zhu Tao? Chairperson, there are no speakers in support of Zhu Tao.
We'll now take speakers in opposition to Zhu Tao.
The first speaker is Dean Archibald. Dean, your 2 minutes begin when you begin to speak. Dean Archibald, are you with us? Dean, if you're speaking, we cannot hear you. would like to speak in opposition to Zhu Tao and are on video, please raise your hand using the Microsoft Teams button and I will call on you when it is your turn to speak. If you're on the phone and want to speak in opposition to Zhu Tao, please unmute yourself by pressing *6 and identify yourself. Is there anyone who has not spoken and wants to speak in opposition to Zhu Tao? Circling back, Dean Archibald, are you with us? Is there anyone who has not spoken and wants to speak about Zhu Tao? Chairperson, there are no more speakers for Zhu Tao. I see we have a hand raised for Dino Paraskevopoulos. Is this for the Clark case?
That's correct. Thank you, Commissioners, for allowing me. This is back on item number 28, Andrew Clark. What's clear is the inmate is a very violent offender that has a history of marijuana use, cocaine usage, and heroin use at ages 13 and 14 that began. His crimes are ultra violent. They occurred in San Diego County and in Riverside County. Specifically, the board received confidential information dated February 11th, 2025, a report from an investigator that dealt with basically two lies that the inmate provided to determine whether he lied. The first one was whether he lied when he testified at the hearing, the parole hearing, his last parole hearing, that a doctor told him to lie and say he was having substance abuse withdrawal problems in order to get into the MAT program, in order to get prescribed Suboxone. So that's the first lie, whether that's true or not, whether a doctor told him to lie in order to do that. Number two is his continuing lie for over 2 years from December 15th, 2022 through the parole hearing date, his last parole hearing of January 14th of 2025, to continue that lie in order to take daily doses of 12 milligrams of Suboxone. It turned out to be 760 doses that was established in the testimony at the hearing, and whether or not that was a lie, and whether, and number three, whether or not the inmate lacked the understanding of what he did being wrong. And he didn't. He thought it was okay. He testified as that. Then he was granted parole. The confidential report came out February 11th of this year to address those issues, as well as restitution fraud. Commissioners, Mr. Inmate Clark's manipulation, his criminal thinking, and antisocial behavior continued for 2 years by lying to get into this program, lying to continually obtain Suboxone, and be in that MAT program for over 2 years and get 760 doses. The inmate's lies.
Your 2 minutes have elapsed. Please conclude your statement.
Thank you. This warrants a rescission hearing. Thank you very much.
All right, very good. We will now take comments from anyone who has not yet spoken and wants to comment on a case on today's agenda.
Is there anyone who has not spoken who wants to speak in support of or opposition to any case on today's agenda? If you're on video, press the raise your hand button. If participating by phone, unmute yourself and identify yourself. Chairperson, there are no more speakers for today's cases.
All right, we'll now move towards the open comments section of today's meeting. Does any board member wish to request an agenda item for a future meeting? All right, hearing none, we will now hear comments from the public regarding general matters related to the board. We are not taking comments on cases. Comments concerning future parole hearings are not permitted during this meeting. Please send those comments to the board for inclusion in the materials for that hearing. Comments are limited to 2 minutes and there's no opportunity for rebuttal. Please wait to speak until we call your name or identify you by your login information. I do have 2 speaker cards present, I believe, for people presently in the room. We will start with those. Mr. Danzel Nunsuch, are you present, sir? All right, hang on, let's get the mic on for you, sir.
I want to thank you for the work that you do. It's extremely important. Commissioner Barton, 5 years ago, your decision to grant me parole marked a pivotal moment in my life, setting me on a path to transformation and growth. By giving me a second chance, You didn't just unlock a door to freedom, but you opened a gateway into a future filled with possibilities, opportunities, and responsibilities that I have strived to fulfill with dedication and purpose. The journey since has been remarkable. Since my release in April 2020 during the height of COVID-19 pandemic, I navigated numerous challenges with determination. I volunteered at the Yolo County Food Bank, completed the Northern California Construction pre-apprenticeship program, which led to me a role in the local 185 and a job with Tiger. My dedication to innovation and inclusiveness was recognized in 2023 when I won the Northern California SBDC Inclusive Pitch Deck competition, further validating the path that I'd chosen. I co-founded Brand Lift 360, a marketing agency dedicated to helping businesses elevate their digital presence. Through Brand Lift, we employ 6 individuals, multiplying that positive impact your decision had 5 years ago. Beyond my businesses, I embrace leadership roles that allow me to shape my community's future. As a board member of Sacramento Entrepreneurship Academy, I help nurture the next generations of business leaders, providing guidance and resources to empower them to succeed. Additionally, I serve on the Leadership Council, We Prosper Together, an organization that's committed to creating a sustainable future for our economy and our region. I found love and partnership with my wife, Jennifer. Together, we have established roots in this community by purchasing a home in Roseville.
Your 2 minutes have elapsed. Please conclude your statement.
Again, the work that you do is important, and I want to thank you today for doing it, okay? Thank you.
Thank you, sir. Our next speaker is Benisa Nelson Sloan.
For some time now, we have been bringing to the board's attention, not to say harping, on the issue of restitution avoidance as a cornerstone for denial. We've spoken on what we see as the legal issues, and yes, we're aware of 155.5B, but it would take an industrial strength rubber band to stretch the rather paltry amounts placed in plain sight on prisoners' books to meet the hidden assets test of this citation. More on point, for literally decades, the board has been paroling those who have participated in this practice and paroling them successfully without detriment to the recidivism rate. We continue to question how now to use this issue as a primary reason for denial is equal application of and protection under the law. We've also been concerned about the potential impact to the parole grant rate to use restitution-driven denial might have, and it appears our concern has been warranted. New figures show that the grant rate for 2024 will likely be around 30.5%, down only 4 points from the 2023's 35%. We understand various factors can impact the parole grant rate, but there's nothing of significance has happened lately. No new cohorts into the cycle, no impactful laws, no new processes that would account for this decrease in the parole grant rate other than the use of the restitution issue. Of course, grant rate is not the primary concern of the board, and we understand that. But for application processes and practices, those should be maintained over time. We'll continue to monitor this and track this problem and remind the panels of the damage to hope, that key motivator of change that is being done under this service, in the service of events that happened often years ago and have ceased to happen. Thank you.
All right, thank you. I don't believe we have any more speakers in the room, so we'll turn it over to our moderator to see if we have any online.
If you would like to make a general comment or on video, please raise your hand using the Microsoft Teams button, and I will call on you when it is your turn to speak. We have a hand raised for Armando Munoz.
Yes, Armando Munoz speaking. I too was granted parole in 2021. I'm a sponsor for Benny Espinoza, and I've watched this man grow phenomenally, so much that he was able to walk away from a lot
I'm
of
very
chaotic.
sorry to interrupt you, but this is a time for general comments about the board. The time for comments about specific cases has passed, but if you have a general comment, you can continue.
Okay, thank you very much.
If you would like to make a general comment by telephone, please unmute yourself by pressing *6 and identify yourself. Is there anyone else who's not spoken who would like to make a general comment? Chairperson, there are no more speakers.
On behalf of my colleagues, I wish to thank everyone for participating today. We will recess the open session of the Marks Executive Board meeting at this time. We will return briefly following closed session to adjourn today's meeting.